fact is inconvenience in order to.
Yes.
Your Lordships, I mean, we see your Lordships.
Yes, like,
Your Lordships,
yes,
pardon me.
like,
Your Lordships on CRLMC number 3352 of 2022. Benazir Bibi versus Republic of India. Your Lordships had allowed the mentioning, but he's not listing it, Your Lordships. That mentioning was allowed, Your Lordships.
give the number once again.
Yes, Your Lordships, I'll file memo once again, Your Lordships. 3352 of 2022.
Your junior is here.
He's there,
Can
Your
you please
Lordships.
send a
Yes.
memo? Huh?
Yes,
Send a
yes.
memo. I'll just check it out.
Yes, Your Lordships.
Yes.
Pardon to mention, Your Lordship.
Yes.
Pardon to mention, Your Lordship. Item 108, Your Lordship. This matter, Your Lordship, has already been heard, Your Lordship. And one clarity is needed that need to be placed before Your Lordship. As because the opposite counsel was not present that day, the matter is listed for today, sir. Lordship, kindly hear this matter, Your Lordship.
Vigilance.
There is no one for vigilance.
He's there, Your Lordship. He will be appearing,
Okay,
Your
let
Lordship.
us see. We'll see 3:30 how the bench moves now. Today
Your
we'll
Lordship,
see.
only one clarity is needed to be placed before Your Lordship. Only one clarity, otherwise it has been heard, Your Lordship.
We'll see. At 3:30, we'll see if I can reach there. I will take it up.
Obliged.
How much
obliged,
time
sir.
will you take? Okay, then how much time will you take?
Only 5 to 10 minutes, Your Lordship. Only one clarity, and then I'll be finishing up.
10. You will take 10 minutes. He'll take 2 minutes means 2 multiply by.
No, Your Lordship. 5 to 10
Okay,
minutes max,
we'll
max,
see.
Your
I'll
Lordship.
see. 3:30. Okay, 3:30.
Okay, yeah, thank you. Obliged, Your Lordship. Obliged.
Yes, Your
Any
Lordship.
mention?
Your
Yes.
Lordship.
Yes, sir. Jinnah Babu.
Your Lordship, item number 35 of this weekly list.
It has already been done, sir. Don't
Oh,
worry.
yeah,
It is
okay,
already been
okay,
done.
Okay, yeah,
Yeah.
okay.
Mention from item number 1 to 8.
Item 2, my lord.
Hey, Mr. Naik is still there. Are you mentioning anything?
No, Lordship, somebody else will mention item 20 to 24. I'm waiting for him.
Okay.
It's called.
Opposite. Yes.
My lord.
Yes. 1 to 5.
1 5.
Yes. 5.
2 weeks after.
My lord, item
On the
2.
request of court.
My lord, item 2. Amicable settle between the parties. One more week time maybe to
What are the
appear.
offenses?
My lord, 323, 324, 506, my lord, and 294.
Are they coming today?
No, my lord, 1 week time. Due to some unavoidable circumstances, informant could not appear.
2 weeks for them.
My lord, kindly next Monday.
No. We will not accommodate according to the convenience of accused. Convenience of lawyer, I can understand. Not accused.
My lord, convenience of the informant. Accuracy present, my lord.
All right. But after 2 weeks. Huh?
Obliged.
Put a fixed date video so that he can come. Yes.
Obliged.
Yes. If you can come today, I can take it up today.
My
2
lord.
o'clock. Will he come today?
My lord, no, my lord, informant could not come.
Okay. Yes.
Obliged.
Item 9 to 23. Item number 10. It's for 2 weeks.
Okay. On the request of on behalf of who? Petitioner. Okay.
My lord, item number 20. My senior Mr. Acharya is very unwell. So, my lord, let this
20.
item number 20 and 24.
Your Lordships, 20 and 24, the matter is mentioning, Your Lordships, the similar issue, Your Lordships will remember that Aditya, where summons were issued, Your Lordships, that matter is listed after 8th, Your Lordships. Then let all the matters come together, Your Lordships.
After it. After it.
Same case.
Okay.
My lord, item 11.
20 and 24, na?
Yes, my lord, 20 and 24.
20 and 24 after it.
Yes. My lord, item 11.
Obliged.
Anyway, urgent to after 1 week.
11 hours. On petitioner?
My lord.
Okay. Petitioner. Yes.
Item 25 to 38. 29 minutes. 1 week after. 26.
For petitioner.
My lord.
26, my lord.
These are fresh matter. Why don't you do it and finish it up?
Personal difficulty. I'm
Okay.
not here.
It's all.
Item 26, my lord. Next week.
Petitioner.
Petitioner.
My lord, item 25 on behalf of Mr. M.K. Panda. Kindly in 1 week.
Manoj Punda. Petitioner. Petitioner. Okay. Yes.
39 to 48.
Item 44. I'll check now.
40.
44. 440.
Yes. For petitioner.
Yes, ma'am.
For petitioner.
49 to 60. 61 to 65. 66 to 70. 71 to 78. 79 to 84.
Item 80, my lord. On behalf of Mr. Mr. kindly.
80.
I don't let it go, Mr. 20.
Petitioner.
My item number 82 on behalf of Suryakant Dwivedi. Kind of taken a one week after.
82.
My lord.
See, 2015 matter.
My
What happened? Entry order is there?
no, my lord.
No. Huh? Further. Simply urgent. No? Simply urgent on request of petitioner. Entry order is not there. Last time it was not extended. Not time it's made clear. Simply at the request on the request of your counsel, Mr. Dwivedi, the matter is earlier. There is no entry order.
85 to 92.
85, my lord. Senior counsel, Mr. Mishra is supposed to argue, my lord. He has some personal difficulty, my lord. Then 1 week after, my lord. Item 85.
85.
85. Interim notice is there.
2017 matter.
My lord, only 1 week, my lord. No further time.
Yes, only 1 week. See, you people have taken stay and for unnecessary seeking adjustment. See the number of hearings. Just see.
Yes, only with this week, my
But
lord.
there is a stay. This is the
No,
problem.
my lord, not
2017 years. The other matter 2015.
personal difficulty for Mr. Mishra.
Personal difficulty. How many times? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 times. Personal difficulty.
As a last chance, my lord, this week only.
This is unfair to you can't do that.
Next week, any day, my lord.
Khali simply adjourn karo. No entry order. I will not say anything. Simply and the
It was
request of
continued.
and counsel for the petitioner adjourn. Yes.
91, my lord.
This misuse. Nothing else. Yes. Yes. Next.
91, my lord. Next week, my lord.
Next week.
93 to 100.
Lordship, I am for item number 93 on behalf of Mr. Ratha. I am seeking for an adjournment for next week.
Unless
Lordship, interim management. Lordship, interim management to continue.
sorry, I couldn't follow you.
Sir.
Which item you are talking about?
Lordship, I am for 93.
93, yes.
On behalf of Mr. Ratha, due to some difficulty, he may not be available. So I am seeking for an adjournment.
The same story here also. Stay is there, then all personal difficulty comes. Simply adjourn.
Lordship, interim management may be
Simply I am
continued.
adjourning, yes. Next. I will not say it.
101 to 108. 109 to 112. 113 to 117. 118 to 125.
How many matters you do? Okay.
126 to 129.
My lord, 126. The section may be directed to prepare the paper book, my lord.
See, you can take the trial court record in a pen drive and prepare it if you want hearing. Otherwise, unnecessary delay. We are trying to done away with the practice of preparing paper book and all because it's going to be paperless court. So you tell your junior, get a pen drive and take it from here. It is permitted, no problem. You tell where is your junior who is assisting you. Please come today itself. Please come today itself and take the entire record.
My lord, the date may be fixed for hearing.
Date will be fixed. No. You get ready. Whoever is ready at 3:30, I'll try. If it's possible, I'll take it up.
My lord.
Okay. Yes, sir.
CMP 2017.
CMP हमको उसको. 69.
Yes. Interim order to continue.
Let us see what interim order you have.
Yes.
How many adjournment you have already taken?
First time, Lordship. Last occasion notice was issued.
Okay.
Yes.
Service for you. Appear?
Yes.
Have you told the other side?
Lordship, I don't know who has appeared also.
No, you have to tell because see, there is a stay operating against them.
Yeah.
They've entered appearance. Behind their back, you take adjournment, they'll come and create
Yes.
problem.
Lordship, only short
I'll
adjournment.
adjourn it, no
Yes.
problem, but let
Inform
it be
court.
called. Huh?
Yes.
Let it be called.
Yes.
I'll adjourn it, no problem.
Yes, obliged.
ठीक है. Yes.
Your Lordship, CRLMC of 2022, it was posted for 21st. It never appeared in the list. Your Lordship may kindly grant a
Give the memo and see what can be done. Yeah. Yes. Yes, sir. Item 1.
Challenging the proceeding before the special court. This application is filed, rejection of application for discharge. The Special Court Act, my lord, permits for trying of the offence committed by persons holding high public and political office. So I must come under the definition of high public office in order for the trial, for the court to have jurisdiction. Your Lordship may kindly see Annexure 5.
What are you, by the way?
I was a joint manager in Orissa Police Housing and Welfare Corporation Limited, which is in the post of Assistant Executive Engineer, and the department had Annexure 5, Lordship may kindly see it as page 49 and 50.
Yes.
49 is the letter written by the Odisha State Police Housing and Welfare Corporation to the...
You're not a, you say that you are not a Group A.
No, not Group A. And similar cases, this Honorable Court has sent it to the court having jurisdiction over the matter.
Yes, sir. He's not a Group A officer. Huh?
Apart from that, it's the question of maintenance of section 480 of the CrPC or the improvement. If there is no signature, no stamp, it's source I have to.
This is
This
opted
may
under
be
RTI Act.
RTI.
Like that, there is no stamp or seal or anything.
Apno instruction niyandu.
It's a false document. It has been, it's thought.
Then I will submit an affidavit substantiating this fact that I have obtained it under RTI Act. When he has raised fraud, Lordship.
That's a matter of trial.
Lordship, when he has...
No, instead of going into all this thing, you just simply tell me whether he is an high official according to another. See, suppose the exercise takes place, taking your submission to be correct, and eventually it was found that he is not an high official. Everything
the entire proceeding will be useless.
Don't go into technicality, simply tell high officer is there, then it's all right. We'll send it. You may be technically correct. Let us come to the practical 14. Yes, this is RTI.
Lordship.
In this last part, he was on the pay scale of 9,334 grade pay 5,400. In this context, it is intimated that Board Pradhan Joint Manager is now coming under class 1 group A category.
Now, the date when it is issued.
This is the at that relevant point of time.
Next page.
That apart from that, it is a resting upon that government decide he was holding high public. We cannot say whether he was holding high public office or not. It is the resting upon the government has issued the notification.
The department has...
Show me that notification.
5-1 notification, after 5-1 notification, it was the proceeding was initiated before the special. And special court, and now he is disputing the same that I was not holding high public office. And that's a matter of trial. It's a factual aspect, it should be tried.
Can I just see that notification if you can?
Notification, Lordship. 1 minute, Lordship. 1 minute, Lordship. Just a minute.
Same similar issue. Was before
Notification is at page 4 of my application.
Page 4?
Page 4 of my application. I have quoted verbatim.
Yes, page 4. Let's see. While holding high public office in the state of Orissa.
Lordship, I have stated that this is wrong in view of The question is, Lordship, the question is, Lordship, Group A, Group B, Group C, these categories are governed by the scale of pay.
Yes.
And
What is the judgment?
the department at page 50 has very categorically submitted. The department at page 50, Lordship may kindly see the last line. The post held by Sri Gaurahari Pradhan was not coming under Group A category during any period between 1/6/94 to 38/2008. This is the check period. This is the period of the offense. And my learned friend has stated that I have committed fraud in filing this. I will file an affidavit. I can be sent to jail.
Why it was withdrawn?
CRLMP was called for it. Is the similar matter. It is the similar matter. Herein the application for discharge was rejected. The same question was raised. That is why it was dropped. Because it is raised herein again.
That can be done in that way, not in other ways.
It is rejection of the application for discharge. Rejection of the application.
Which paragraph you are relying on? The para 5 is relevant. What eventually it happened?
That is the same issue. They filed a discharge petition, raising question that why I was not holding high public office. This honorable court was that no, it's a matter of time. It should be advocated in sort of time. And your lordship kindly see the CRLMP is in that is perhaps it has form.
CRLMP टा देखिए. सही same question.
And this order against this, there is an appeal lies.
No. It is a rejection of the application for discharge. It is a rejection of the application for discharge.
Yes.
17 is against the order of the authorized officer.
17 of
Special Courts Act.
Special Court.
Special
He
Courts Act.
directly, sir, he directly covered by this judgment. Have you seen this judgment? Directly covered. Same issue, Group A service. The issue was not a Group A service, and the court said
Similar applications have been allowed by this honorable court, wherein I was the advocate.
This court's order,
Lordship,
in Nuram Agarwala,
Unfortunately,
is directly all big matters. The council changes side. Special court section.
17 देखिए Lordship.
Yes.
Any person aggrieved by.
How will you deal with this judgment? You just tell me.
Lordship.
How will you deal with this judgment?
Lordship judgment देखिए party रो ना कहले I can. Gopinath Viswal.
You have argued this matter.
Gopinath Viswal is a different case. Gopinath Viswal is a case where there is.
Check it up.
He was convicted and appeal was pending.
Para 5 and 6 is very, very clear about it. Just check it up. I'll just send it. Check it up. He directly covered. According to me.
ठीक है मुझे देखी देगी कोई Lordship में.
I'll just.
Okay.
Next week or so.
Okay.
filing of counter. It was
Same question. Application for discharge.
You have two serious difficulty. One is this judgment. Second is CRLP. But
CRLMP will not come on my way because I have challenged the same thing. That is why I have dropped one.
But one more thing you tell me, after your discharge application is moved, you obtain something in RTI. How can I go into all this?
No. Prior to that, I had
whatever, but these are not the form part of the charge.
Lordship, may kindly see the rejection order. In the rejection order, the learned trial court says that 5(2) of the Act bars the trial court from inquiring into the matter when there is a declaration by the state government. In other words, the trial court says that once the declaration is made by the state government, it can only be challenged before the High Court.
You tried in another proceeding.
Lordship,
you tried in another proceeding and after the counter you
my only grievance herein is that, Lordship, if I am not coming under the purview of high public,
the same issue you keep on challenging in different forum, fails and file another petition, withdrawing, and all these things are No.
That record is there.
This-
That record is
Anyway,
there.
you just check it up. You are done.
Yes, yes,
According to
yes,
me, he's
yes,
direct
yes.
copy.
Lordship
Yes.
may keep it to, I
Simply
will,
1 week for
I will go through all the order sheets and accordingly I will submit.
Simply
That
approve.
will not come in my prop.
Next.
Way.
Item 3.
Is the interim order to continue, Lordship. Interim order is there.
Yes.
Next page.
This is a matter, amicable settlement.
What are the
First
offences?
occasion 307 with another, other offences. Last occasion it was there, both the parties were present, my lord directed the state council to take instruction. And
I have written the letter, but I have not received the instruction.
Sorry?
I have not received the instruction. I have written the letter.
Twice. The petitioner, the state submits that he has not yet received the instruction.
that was also there in the.
Pursuant to the order dated 6/2/2025 and seeking in accommodation, leaves the matter after 2 weeks. Yes.
Item 4.
But when it will be,
Yes, he'll give a date.
but
Yes. He'll give a date.
well,
Okay, give it. Yes.
Item 4.
May I please, Your Lordship?
Yes, sir.
My lord, here I have read was the proceeding, my lord. Here in this case, my lord, what happened? The incident was occurred and FIR and counter FIR was lost, my lord.
Yes.
The IO investigate into the matter and collected some evidence also recorded under section 161 CrPC. He finds therein that 3 SC/ST Act is not made out. He prayed to the trial court to accept the prayer of the IO, and that was allowed. He arrested some accused persons, forwarded before the Clement court, that is JMFC Banki, SDGM Banki, and they were released subsequently on bail. The subsequent IO, after the transfer of the first IO, subsequent IO, he submitted the charge sheet under section 161 CrPC, under section 3 SC/ST Act, including other offences, submitted the charge sheet under section 3 of the SC/ST Act, without praying to the trial court to accept the prayer of the IO. He has not prayed, without taking any permission, he submitted the charge sheet without recording the statement.
Once the charge sheet is filed, it is the trial court job. He need not keep on praying, take cognizance. Job of police is, after investigation, he has to place the charge sheet before the court. That then the court, he need not request the court, please, I have filed the charge sheet.
One IO,
Cognizance and this. He's not.
one IO to accept the accused persons without the offence under section 3 of the SC/ST Act.
Simply you tell me whether in the charge sheet, whether that offence is included or not.
Yes. Yes.
It is included.
Yes.
Then once it is included, is no one, the IO has no business to tell the court that I have filed the charge sheet in this section, but please ignore it. Who is he? Who is he?
No, Your Lordship could not go out. I think I am
That's what
unable
you
to.
say.
I am unable to.
But says that requested, don't take
But
it.
the first IO prayed the trial court. He investigated into the matter.
First IO has filed the charge sheet or not?
No.
If he has not filed the charge sheet, why have you, where was the occasion for him to go and pray?
My lord, he arrested the accused persons. He was the IO of the case. He investigated into the matter. He arrested the accused persons, prayed the trial court that SC/ST Act is not made out. So
Where is that? Where is that?
my lord, I have
Where was the
annexed.
occasion for doing?
Yes, I have annexed the document.
Where is that? So me
That is, my lord, the annexure,
prayer of the IO.
page 39, Your Lordship.
30?
39.
Yes,
Annexure 3, my lord.
39. Yes.
My lord, the last para.
What is this document? What is this document?
My lord, Your Lordship may see the prayer for elimination of section 3(1) RS of the SC/ST Act. The IO prayed the trial court. And that has been allowed. Accused persons were forwarded to the SDGM Banki. Neither, my lord, they could have been forwarded to the special court.
What is this procedure? I never understand.
I'm taking instruction. I'm calling for the records.
Now, why the IO has moved an application saying
Yes, ma'am.
that please remove this section from the FIR?
It is not proper. Yes, I am calling.
What kind of where was the occasion and why when what provision he has done it? IO moves an application
Yes.
saying that from the FIR remove this section.
Yes, ma'am. Let it come 2 weeks after.
And what he says is after one IO has given this and second IO files the charge sheet.
Yes.
If this was allowed by the court, the second IO has no business to do it. That's what his case is. But how has it been done?
Yes, I will take. I'm taking it.
The second is come to page 40 again.
Yes, similar.
Hence, it is clear that except the FIR, along with the record excluding so and so POA. I don't know what kind of procedure. And next, come to page 41. The second IO comes and says that add this section in the FIR.
Therefore, listen to. And maybe added in the FIR.
A peculiarity is similar. The second IO not examined the witnesses.
What kind of practice?
Take it after 2 weeks so that
Issue notice. Issue notice. Take out lesson to it. Least the matter. Yes.
Item 6.
Yes.
Let further proceeding.
Where is the further proceeding? Where is it?
Before the SDGM bank errors.
No, why for? Whether it is with ACST or without ACST, I don't know what is happening.
Miller, that has been that record has been transferred to the special judge.
We don't know that. Let us get it. This the entire thing has to go.
Nothing will happen within 2 weeks.
If this is the practice adopted. Ladaji.
For proceeding, Miller, I have prayed for further proceeding stay, Miller.
Further proceeding.
State is just swearing, na? Nothing.
State, let the state get the information. Let us see. I'll do it. Issue notice on the IA also. Issue notice on the IA also. Take issue.
Record
No. Notice on IA also. I'll hear the IA. This practice I have not yes.
Item 6.
Yes.
Item 6.
Sir, the CBI case. So the copy
No.
So the proceeding is continuing against the wife. Husband has died in the meantime in a disproportionate of asset case since 2005 when the charge sheet was filed. Husband has died in the meantime in 2021. Out of the in last 16 years or so, 53 witnesses have examined.
Mr. Naik is on his left.
He's already there.
He's there.
He's already. Yes. Yes, sir.
My lord, 53 witnesses have examined out of 98 cited so far. I have filed a petition for my lord because of the delay in trial, and that petition came to be rejected, and that pursuant to your lordship, in fact, my lord has held in a case that 109
57 now 57 out of
53 out of 98.
92 out of 98.
Yes, Mr. Naik, how much time?
Audible hona thi
Yes, Mr. Naik, can you hear me?
And this matter your lordship has had in that Srimati E. Swarnalata.
That's a different story already.
No, not bad out, your lordship said 109, a wife, a housewife. Anyway, that is another aspect to it.
What is happening? You come. Come here. You come here. What is happening? Whether he can hear me or not, you have to be here.
I'm just conveying in my system.
It is no doubt first time it is coming.
Issue notice.
The reply has also not been filed yet. We'll file the reply today, Your Lordship.
What is the reply? He says that see 53 witnesses have been examined out of 98. Husband has died. Under the aid of 109, you are prosecuting him.
Yeah,
he wants expeditious disposal of the trial.
Your Lordship. Your Lordship may.
I'll pass an order. You tell me how much time.
Your Lordship may pass over the matter.
I'll pass it over.
Yes.
Why should it be pending like this?
Yes, sir.
See, the husband died long back.
Yes, Your Lordship.
She is facing trial under 109. Substantial evidence has already been recorded.
Yes, Your Lordship.
And you tell me how much time will you take?
Your Lordship.
Accordingly, I'll pass a direction. Yes.
sir.
Pass over.
Your Lordship may also consider that quashing the entire
No,
proceeding.
quashing not possible.
Because
After
109.
53 witnesses have examined, shall I evaluate the evidence now?
No.
Your Lordship, audible?
Yes, Mr. Naik, you sometime you are audible, sometime you are vanishing.
No, Your Lordship, actually there was some problem in the network.
I was addressing to your chair, empty chair,
I'm so sorry, Your Lordships.
because in between hearing you left the chair and left the chair in front of me.
No, Your Lordship, I was actually scolding the internet person because I had asked him to feed this morning.
Please don't do that. Huh?
I'm so sorry, Your
Please
Lordship.
don't do that. This is, sometimes it is kind of disrespect to the
No, no,
court. When I'll tell you, when matter is here going on, switch off your camera when you want to leave. Suppose you are arguing, suppose I'll straight away leave the chair and go. What will happen?
I'm sorry, Your Lordships.
Okay. What he says is that, see, Mr. Sadangi says, out of 98 witnesses, 53 witnesses have already been examined.
Yes.
So he seeks, primarily he seeks quashing, which I am not going to allow, because 53 witnesses have already been examined. At this stage, I will not allow that.
No, 98 are yet to be examined. I'm
So
sorry.
therefore, you give an estimate how much time.
I'm
the
68
prosecution
years
is
of
going-
age, Your Lordship. I'm 68 years of age.
Because a husband has died, wife is facing the trial. You are prosecuting her under the aid of 109. That's the case.
And the last witness examined.
Shall I issue notice so that you can give an overall idea to me?
Your Lordship, I had already filed a reply. Your Lordship, may pass, but target the trial, Your Lordships.
You just tell me a practical timeline you give so that I can pass the order.
Lordship may fix another date, Your Lordships. I'll just seek
Just
instruction.
otherwise, see, unnecessary pressurizing the trial court is not fair.
Yes, Your
Unless
Lordship.
we know the overall idea about it. Okay.
He should also, while taking into note, Your Lordship, last witness was examined on 4/2/2020. That was 20, 5 years ago. I'm 68 years of age. Now, Your Lordship, there is
5 years ago, last witness was examined. That's what is complaining.
and there are also instances where Your Lordship has also referred to that delay in trial entitles me to.
That's right.
Not the fact that 68 witnesses out of 151 cited have been examined.
Okay, then let him get the instruction. You get the instruction.
Yes, sir.
Have you given the copy?
Yes,
Yes,
sir.
Your Lordship.
Without
Get
the
the
copy these
instruction.
days, it is not.
What is the status of, you file a status report. Shall I ask, no, what I'll do is, I'll ask the status report
Yes.
from the trial court. Item number 6. You file the reply, I'll ask for a status report.
Yes,
from the
Your
trial court. Right. Mr. Santun Shodangi, learned counsel for the petitioner, submits that his client is facing prosecution in where is the FIR?
FIR
Prosecution since 2008.
2005 was
2005. In between, the principal accused, namely the husband, his client's husband, has already expired. The
principal accused.
Prosecution is being going on against her under the aid of for alleged offence under section 109 IPC. He submits that 53 witnesses have already been examined in the present case, and the last witness was examined 5 years back. Thereafter, the trial has not been proceeding. As a result of which, the trial is inordinately delayed. Hence, he seeks indulgence of this court for a direction to the trial court for expeding this conclusion of the trial. Mr. Naik, counsel appearing for the CBI, however, contradicts the submission of Mr. Senior Counsel. In that view of the matter, I feel it appropriate to seek a report from the which court ASJ cum Special Judge CBI 1 Bhubaneswar regarding the status of Now the TR case number 2 of 4/2008 on the next date of hearing. Meanwhile, the CBI can also file their response to the petition with release it after 2 weeks. Get a you file, Mr. Naik, you file a reply. Meanwhile, I am seeking a report also.
Yes,
Okay.
sir.
Okay. Thank you.
Your lordship has fixed it to.
I'll give it after 2 weeks. You would date the date. But here you have to give a date because the trial court has to give a report. Give a date. Okay.
And I'm
Yes.
sorry, Your Lordships, my objective was not to disrespect. Your
It's all
Lordships,
right.
how
Just
much respect I have.
this quite that happens. See, we have also faced when the pandemic time. So many things happened.
Yes, Your Lordship.
16th April.
This happens. Yes. No.
16th April.
Item 7.
16th April, yours.
Item 7, my lord, side. Passover.
Passover. Okay.
Item 8.
My lord, in this matter, the present petitioner is filed an application on dated for quashing of the order on dated 21/2025. 21/2025.
21/1/2025. Yes, madam.
An application under section 3.
What is your name? What is your name?
My name is Susmita Malik.
Susmita Mohanty.
Malik.
Yes. What do you want? 20.
Under section 311 of CrPC, for recall the witness PW1 who is the victim.
Oh, victim. Victim is problem because there is a bar.
My lord?
There is a bar 33 clause 5 subsection 5. There is a bar. You can't repeatedly call the victim to the witness box. How will you get out of it? So the bar is not absolute, but there is a bar. What trial court says, trial court must be saying that only. No, same.
Victim is child.
33.5, same. Yes, madam. What is it?
During cross-examination, the contending counsel could not ask any relevant questions of the victim, and as such the relevant question are most valuable question of acquittal of the petitioner.
Where have you said that in your application?
London Code below.
Yes. Where have you said those things? Whatever you are submitting, have you said that in your application? You please prepare properly and come, and get the statement of the victim also. File the statement of the victim, after arguing for some time, Mrs. Malik, learned counsel for the petitioner, seeks an adjournment to further prepare regarding the bar statutory bar under section 33(5) of POCSO Act regarding repeatedly calling child witness. Please the matter after. Prepare and come. Yes.
Item
9.
The complainant is the daughter-in-law of petitioner number 1 and 2. The complainant killed her husband, and the petitioner number 1 filed affair before the court, and he was custody before the police. She was custody for 5 years. After release of bail, he filed a petition alleging that dowry, torture, etc. The annexure for if your honor will see the affair in entirety, it cannot constitute the whole 98A or 506 or 294. Kindly have a glance the allegation against the petition.
This is a matrimonial dispute. What is this FIR 302? What is the first annexure?
First affair, the petitioner number 1 lodged the affair against the complainant who killed her husband, son, my son. Petitioner number 1 and 2
that is not related to this case.
But it is a matrimonial.
Matrimonial.
I'll issue.
No, matrimonial. Kindly have.
Issue notice.
I issue notice. Yes. Next. 10.
And the proceeding may be and further proceeding.
There is a 302 angle also.
30 angle is separate. That is separate issue. That is
If
separate
that was
issue.
separate issue, why have you brought in?
Brought in
PRPTs?
because I want to draw the attention of my lords about her conduct. Who is accused in murdering her husband? So I have filed, and the petition number 1 is the informant in that case, where
All these things
Counter
will settle it. Will settle it out. 498 will settle it out. You have chosen to marry that lady. What to do? You should have verified what is the character of.
kindly have a glance at the kindly take page.
I am issuing notice. We'll see.
Annexure 1 to annexure 40.
I'm with you. I'm sending notice to them. I'll call them. Opposite party number 1 to I'll tell you 1 and 2.8 na? And
1, 2, 3, 3 is the complaint.
3 point notice and file the requisite immediately by tomorrow. Yes. Next.
That's it. Pray for an adjournment because charge sheet copy is to be filed, and meanwhile the matter has been amicably settled between the parties.
What are the offenses?
498A, 307 was there.
Okay. Adjourn. Not request. 498A, then settle.
307.
Let them settle.
May it please your lordship. Here the
13.
May it please your lordship. Here the petitioner is praying for quashing of the FIR registered under 304A and 34 of the IPC. The petitioner is a doctor and it was a case of medical negligence. So before registration of the FIR, the police ought to have obtained a report from the medical board.
That is the requirement.
Yes.
That's the requirement.
But after FIR that was obtained, and my lord, that opinion is at Annexure 2. Relevant portion is at
And
page
FIR was registered on 18/12/2018.
18. Yes.
Where is the where is that?
My lord, Annexure 1 is the FIR.
31/12/2019.
My lord, that is the opinion at Annexure 2, and relevant page is at page 15, where they have completely exonerated the petitioner. That the petitioner.
Yes, sir.
Notice.
Right. Petitioner is seeking quashing of the FIR number Tolabonia case number 84 of 2018, registered under section 304A, read with section 34 IPC. IPC. The petitioner is a doctor, practicing doctor. Allegation against the petitioner so and so. Well, counsel for the petitioner submits that it is mandatory requirement before registration of FIR. It was required under the. Is there any statutory?
No, it's only in pursuance of the judgment of the Honorable Supreme Court.
Do you have that judgment?
Yes, your lord. That Jacob Matthew was
in accordance with the judgment reported in so and so, before registration of the FIR against a doctor for an offence under section 304 capital A. The report from the district report from the Panchayat authority is required to be placed before the police. However, in the present case, the FIR was registered on 18/12/2018 and subsequent thereto on 31/12/2019. The report of the senior consultants bracket O and G DDH Puri has been placed before the police. The report completely exonerated the petitioner. Issue notice to the opposite party member also accept notice. In the meantime, proceeding before. Are you on bail?
My lord, no, he never took bail.
You have not filed any application for any interim order also?
No.
Okay, issue notice.
My lord.
I intended to pass some interim order.
This will be quashed. They can take us.
You are entitled to interim order. Therefore,
my lord.
okay.
Obliged.
May I please your lordship.
814?
My lord, here the present petitioners have filed this application challenging the order taking cognizance in an NI Act proceeding. Your lordship may kindly have a glance to page 16, annexure 3.
16?
16, my lord.
Yes.
That is the impugned check.
Yes. Ma Mangala
Infra Engineering Private Limited. That is a company. Without including the company, the complaint case has been filed against the petitioner.
Show me the complaint.
My lord, that is at annexure 1. Against the present petitioner, also not including them as the director of the company also.
Right. Petition rejected by the order dated 13/7/2023 passed by Letter James Nimapada in ICC 1CC case number 3F4/2023, whereby cognizance of offence under section 138 NI Act has been taken against the petitioner on the complaint filed by the opposite party. Opposite party number 1. Okay, hold on. The counsel for the petitioner has taken me to the annexure 3, petition, where the photocopy of the subject check has been annexed. It perusal of the photocopy of the check reveals that the check was issued on behalf of Messrs. Ma Mangala Infra Engineering Private Limited. The complaint has been filed impleading the present petitioners as an accused, accused on their individual capacity. Neither the Mamula MM Infrastructure Limited nor its directors are implicated as accused in the present case. Therefore, Learned Counsel for the petitioner submits that the complaint is not tenable, not maintainable under law. Under law, issue notice to opposite party number so. In the meantime, proceeding before the judicial magistrate first class Nimapada in 1CC case number 3 of 2023 is state. Yes.
15.
Lordship appearing on behalf of Mr. Mahanti, kindly the matter be posted to another date.
What happened, madam?
Counsel is not well, so feeling not well.
On behalf of Learned Counsel for the petitioner, an adjournment is sought. Please the matter of July. Yes.
16.
Obliged.
Please, Your Honor. This is a staff case. The allegation against the principal accused is the MBI matter. He was remanded 500 rupees and accepted took 300 rupees and paid rupees. Then, without taking, after taking, he has not supplied the driving license and demanded another 200 rupees. That is the case. The case. So during investigation, the vigilance has recommended to the government for sanction, but the sanction was refused by the government, my lord. 98. Again in 99, the department recommended to the for sanction, and the second time also it was refused. After 15 years, again the department received a sanction.
Yes, Mr. Marana, are you serious?
Without any face matter.
97 FIR. Twice you have not given sanction. After 15 years, again giving sanction. What will you do with this kind of trial? That is the reason in the rate of acquittal is, all acquittal is because of this kind of. But what is this? See, if you put these kind of people into trial, they are bound to be acquitted, and the statistics are against you. The acquittal rate is so high. If these are the cases you will put to trial, obviously what will happen? What is the stage now?
This trial is going on, my lord.
How many witnesses have been examined?
Can
you just pass it over? What I'll do is, the best way of doing it is, I'll give direction to the trial court to expedite the trial.
Yeah.
Oh, He is absconding. Oh, what? Sanction nathila.
Accordingly, the trial is going on in respect of that claim. And so far as this petition is concerned, that is not, that is speaker. In case I will take instruction.
But he has moved an interim application. What to do? Kौन करेगा?
Adjournment temporarily.
Okay, issue notice, right on. The petitioner is one of the accused in vigilance, Kotak vigilance PS case number 73 of 1997, registered registered on 9/12/1997. The counsel for the petitioner submits that twice the appropriate authority has refused to grant sanction. However, after 15 years, after lapse of 15 years, fresh sanction has been granted, and the petitioner is sought to put to trial. In the meantime, the co-accused who has accepted the bribe, alleged to have accepted the bribe on behalf of the present petitioner, is already facing the trial, and the trial is at an advanced stage. Issue notice to vigilance, and Mr. Marana accept notice. In the regard being had to the peculiarity of the facts of the present case, I allow the petitioner to move application before the trial court seeking an adjournment. If such application is moved, the same shall be considered favorable. In the meantime, Mr. Maharana is also directed to place on record the status report regarding the trial of the co-accused. Let us see. If he is acquitted, then I will quash it here. Naturally, he will be acquitted. I know that. I will quash it here unnecessary. Yes.
17.
May I please, my lord? In this one, IA is filed. That has not been 852. It has filed one IA.
852
of 2025.
No, what is this? What are you asking in this petition?
To act as the IA, the stay of proceeding in that IA.
Which item is talking?
17.
17. Where is the IA, madam? There is no IA, nothing.
Yes, ma'am. I'm giving the number.
It's not listed.
Yes, ma'am. That's why I'm coming next week with that IA.
No, what do you want basically?
Basically, this is a questioning of proceeding of FIR, my lord. Allegation of 2011, and the FIR was lodged on 2021. For that, I filed one IA for stay of proceeding.
The problem is stay of proceeding is will come subsequently.
Yes,
in the present petition, you have filed only the FIR copy.
FIR copy. Charge sheet, my lord, to the ocean.
You have not filed. First of all, you satisfy me that you have a case. Then the question of stay will come.
Yes, ma'am.
Your case, what is your case? Case is
under 374, final charge sheet filed under 354A, 354.
See, the FIR was registered on 16/8/2021.
121.
What you are trying to say is the incident taken place in
2011.
Where is that? Where can I get?
In the FIR. It's up in the FIR.
See, in the FIR, it is written occurrence date.
No, the
is 16 to 2019.
16 to 9 paper, the complainant has came to the and said that on when she was working as junior clerk in 2011, the accused has misbehaved with him.
In his tenure.
Yes.
Page 10.
Yes, I'm there. ପଢ ନା ମୁଁ ଗତ 2011 ମସିହାରେ
when she is working at that office, the present petitioner has misbehaved with him. Working lady, both the government employee. Both are the government employee.
Madam, incident is not 2011, incident is subsequently 2017. Just see, you read the entire one line somewhere you can't read. Repeatedly, this offense is going on since 2017 onwards. So therefore, the FIR is registered. Just read it.
2017.
He says 2011 he joined as
Yes,
a
yes. And from
officer.
2017
Thereafter you kept on having relationship
Should
with
be
that
from
man.
2017.
2017 you started, continuing till 2019. 19 is the FIR. তারপরে সব অফেন্স হয়েছি
In the FR of 2021.
FIR হি পড়ন্ত আমার
Yes, ma'am.
You don't spoil the case, rather let it be investigated and withdraw it and come in the right time.
No, the final form has been final.
That has been filed.
Yes, my lord.
What are the offenses?
Offense on 354A, 354D, 376-2N.
Then how can I quash it?
SC and ST Act. Notice may be issued. Both are the.
Why should I issue notice? There is
both
currently
are
there is a case.
both are the government employee, my lord, working in same office, and the person is of 61 years old.
Then 61-year-old.
And
the
she
office
is also
you
married
behave-
lady at this false
behave with
allegation
your,
is given. She is also
women
married.
employee like this, then what to do?
Yes, she is also married on a given false allegation. Because of SC belongs to SC and SC category, the FIR has been lodged. Yes.
Better you have not filed anything. There is nothing in this case.
Final charge sheet, my lord.
I am trying to find out way to give you relief, but I am not able to get it.
After next week, also.
Are you on bail?
Yes.
What
Going-
relief could be given in this?
Going,
I can't help you out. That's the whole difficulty.
I'm going to return next
You
week.
tell me what best you can take it from this
Say
court.
totally false. I can both are working in same office, same department. Everything has been done with the consent. But what happened later on? What happened? This FIR has been lodged. Some
Consent is
disturbance
very
made this
difficult.
between the both parties.
And I can't see.
No, the notice
can't-
be issued.
So
Trial
many
is
charge
going
sheet-
on.
So many charge sheet, I'll find out some way to give something. I will check it. One thing is in her favor in this, it looks like 2017 onwards, this is happening. She has not done anything. 3 years she kept on having same relationship. And 2019 something has happened. He is, what is the age of this lady? He's 35. And this man is 61. This must be a consensual thing and unnecessary. This is the reality. He kept on having relationship for such a long time. And I'll issue notice, bring her, let us see. If you can be settled, I'll issue notice. Huh? Place on record, Land Counsel for the petitioner seeks an adjournment to place on record the additional document to substantiate her case. In the present case, charge sheet has already been filed. Cognizance has been taken. We challenge cognizance order, madam. Why are you spoiling this? Withdraw it. And in this petition, nobody will give you any relief. Better you withdraw, challenge the cognizance order, file all these things. You may get something.
Yes, ma'am.
Land Counsel for the petitioner submits that she has, although she has filed the present petition seeking quashing of the FIR.
Yes,
However, in the meantime, charge sheet has already been filed on such and such day, and cognizance of offences.
30/10/2021.
Give me.
30
Cognizance
days
of offences has already been taken by the court below for under section 354 capital A, oblique 354D, oblique 376 2N, oblique 376 2B of IPC, reading section 31W Roman 1 Roman 2 and 32V of ACST PO Act. Since cognizance of the offences has already been taken by the court below, Land Counsel for the petitioner fully alive. Land Counsel for the petitioner seeks to withdraw the present petition to file a better petition, assailing the order of cognizance. Certified copy of the FIR filed in this petition. The give it back to him by taking the. Okay. With this liberty, the petition is disposed. Yes. Next.
Item 18.
Petition applying for quashing of criminal proceeding in view of the compromise between the parties.
What are the offences, sir? Okay.
Offense under the matrimonial dispute.
I'm issuing notice. Issue notice.
My lord, date may be fixed, so that
Date fix कर दिया 498 वगैरह अच्छी वो date fix कर दिया after 2 weeks file the requisite by tomorrow. Requisite to be filed by tomorrow. Yes.
so that both of are present before the summary.
I will not give direction. You will settle, you bring them.
My lord.
I'll do it.
Short date may be.
Yes, short date. हाँ? नहीं 17 तो very good. Dispose the felon. Yes.
19.
19, madam, in this application, the petitioner seeks for quashing of criminal proceeding. The ground of settlement, my lord.
What are the
Offence under section 307 and other offences, my lord.
Show me the yes.
Para 7 I have mentioned, my lord.
Para 7.
My lord.
Of your petition?
My lord.
Okay.
Page 4, my lord.
What you will say?
And it is humble sound that admitted the petitioner and informant belongs to one local due to some misunderstanding.
Injury, you tell me the injury.
Injury report or nahi again.
307, that is the important thing.
My lord.
I'll simply issue notice.
My lord.
Check it up. Yes.
Item 18, Item 18, stay of further proceeding.
You bring after 2 weeks, I'll quash it. What are you talking about? I'll quash it. Why stay? Yes.
19 date may be fixed.
Yes. You have not filed anything. 307, you want quashing. What is the stage? We don't know.
The charge sheet has been filed.
Where is the
Cognizance.
charge
I have
sheet?
annexed the cognizance order, my lord.
Where is the charge sheet?
Annexed to 1 page 8.
Charge
Cognizance.
sheet.
Charge sheet को फिटानी.
307, what are the injuries? You don't know.
Date will be fixed on
What
that date. I will file the
And
injury.
who is the injured?
Injured, my lord, OP number 2, my lord.
Number 2. Okay. You bring them. We'll see.
My lord.
Yes.
Item 21.
May it please your lordships. The petitioner challenges the order of cognizance dated 31st October 2013 as per annexure 3 at page 31.
Yes, yes, I read it. Next. Show me what are the allegations.
This case arises out of a complaint case filed by the informant against the petitioner and 2 other persons. I would like to draw your lordship's attention to running page 16, internal page 3 of annexure 1, the affair. Your lordships may come to line 6, line from the top. चंचकता पूर्वक बेदंडा दलिल 12/4/2010, the date of occurrence. On this day, alleged fraud has been practiced as per the affair, and the affair has been lodged by the informant in the year 2022. 1cc case was filed.
Yes. You come to page 28.
Page 28.
28. Last 5-6 line.
Yes.
Here
I would like to say, my lord, I have Nilamani Das with the President Mohori. My lord, here may come to annexure 4. Annexure 4. Annexure 4. Annexure 4 is the identity card issued by the District and Sessions Judge Bhadrak. The petitioner is a registered clerk with the District and Sessions Judge Bhadrak. It is none of his business to scribe a deed of sale deed.
I don't know. You might have impersonated. Who knows it? At this stage, how can I go into all these things?
My lord, I am challenging the cognizance. There is not a single word against me.
161 statements you want? Huh? Where are the 161 statement of the victims and informant?
Informant say I have the certified copies, but I have not annexed those documents.
That is how I have to get to know how this findings of the what you call the IO in the charge sheet. Unless you file entire document, how will I access it?
My lord, I may be
2 page petition you file and you want quashing like this. all the see at this stage, if you want quashing, charge sheet has been filed, then the entire charge sheet has to be placed before me. Right now, counsel, but the petitioner seeks indulgence of this court under the inherent jurisdiction, seeking quashing of the order dated 31/10/2023 passed by passed by JMFC, then JMFC Dhamnagar in GR case number 621 of 2023, whereby cognizance of offences punishable under section 323, 294, 420, 506, 34, 34, 466, 466, 468, 471, 470 IPC has been taken against the petitioner, besides other two accused persons, namely Narayan Sutar and Savitri Sutar. Sutar. Learned counsel by relying upon the I-card, identity card issued by the identity card of the petitioner, submits that petitioner is a registered clerk. And there was no occasion for him to be present in the registrar's office as a registrar office, being registrar office. The entire case is false. The informant falsely implicated the petitioner, projecting him as Morier. Except the copy of the charge sheet, no other evidences form part of the charge sheet. No other documents form part of the charge sheet has been placed on record. Moreover, the petitioner relying upon the identity card issued by the civil judge Bhadrak.
Registered civil court Bhadrak.
Which is whether the same is form part of the charge sheet or not is not also whether the same is form part of the charge sheet or not is not coming forth. Hence, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to move specific application before the trial court, urging all the points at the appropriate stage and appropriate stage. With liberty, the petition is disposed.
May I pray one thing, Lord? My Lord, may I call for the
I have given you liberty. Yes, next.
my Lord, my prayer is let the records, the police records be called for by original.
Why should I call? Why should I call? Everything is supplied to you. You don't file, and this court will keep on collecting annexures for you.
My Lord,
it is your responsibility. See, 207, all the copies are given to you. You don't file. You file selective document. When I ask something, then you say that ask the other side. Why should the other side will place it on record? And moreover, you are relying upon a document. You are not able to tell me whether it is form part of the charge sheet or not. Yes.
No,
next. Yes.
May I pray, my Lord, let this matter come after 2 weeks. I will file this.
I have passed the order with. I have not prejudiced you. Rather, I have given some liberty to you. Yes.
I am challenging the notice of 133 BNS press for quashing of the proceeding. And
what are the offences, sir?
59 of 2025, page 15, my lord. In this case, my lord, initially the present petitioner lodged an FIR before the police station, my lord, on dated 20 March 2022, my lord.
Yes.
And then in the meantime, my lord, the police officers not registered the information, and thereafter I filed a complaint case before the Human Rights Commission on bearing number 390 of 2024, my lord. And which was a disposal, my lord, 17/12/2024, my lord, on the direction, my lord, and lodge an FIR, my lord. In the meantime, my lord, on the very next, my lord, and the police has lodged an FIR, and subsequently, my
You
lord,
see, you are challenging Annex 2.
Yes.
Can you read it? Read it for me. Can you read it for me? I can't read it. Not a single word.
Here I will file.
Now you type it and file. The order which you are challenging, I am not able to access it. Then counsel for the petitioner submits that he would be filing the typed copy of the annexure 2 along with the additional document to substantiate the case, leave the matter. You file the type.
Next week.
Yes, next.
Okay.
Your Lordship.
Yes.
Here, ballot, the petitioner has challenged the proceeding initiated against him, madam, for the offences under section 294, 323, 506, 34,
Yes.
add with section 3 of SC and ST Act, ballot. Ballot, the first contention would be accepting the entire case, no case is made out.
Yes.
Second, my lord, I have also raised the point or the view taken by the Honorable Apex Court in Priyanka Srivastava's case, my lord.
So let us see that's.
My lord, may annexure 2 is a complaint.
Annexure?
2 is a complaint petition.
Okay.
Page 28.
Page 35.
Page 35. I am the sole complainant in this case. That is the issue also. Nothing is in line of Priyanka Srivastava. Ballot may see
Yes.
Priyanka
What do you
Srivastava's
say?
case. I have
See, the problem is
quoted ballot in paragraph 14.
it must be this.
Paragraph 14 I have stated so, my lord.
From the bare perusal of the complaint, the offense is clearly made out, but technically that may not have done.
Yes, the problem is Priyanka Srivastava is nobody is complaining.
Yes, sir.
And the real problem, I'll tell you, the real problem is the junior counsels, those who are practicing in the trial court, they go by the guidance of the seniors. And this was
Go by the
trend.
format, so to
This
say.
was the trend earlier.
Format.
They copy pasted and file it.
My lord.
And they without realizing that there is a judgment now.
I have stated so in paragraph 14 and the entire guidelines.
That's the whole difficulty.
That's from the bare perusal of the complaint.
No, if my learned friend is insisting upon that,
I'll simply issue notice. See, Priyanka Srivastava is not complied. It is arising out of a complaint case. Priyanka Srivastava need to be complied. And prima facie, I find there is the problem. And in almost all the cases is like this.
Nobody is taking serious
No,
note.
Priyanka Srivastava standard, if you apply here in Orissa, I think all the complaint will be quashed.
In some cases,
All the complaint will be.
some cases they are following nowadays. Nowadays, ballot in some cases, first ballot after this judgment was delivered, I had relied upon it and case of
The kind of affidavits filed in this court are
Ayodhya
like
Panda
that.
was
What to
stayed.
do?
First, in the vacation bench, I had raised this point after this judgment was decided, was pronounced.
The present case is arising out of a complaint filed by the opposite party number 1. Opposite party number 1.
Ballot.
And opposite party number 2. 2 being 1cc case number 23 of 2024. At the outset, Mr. Dhar, taking me to the complaint at annexure 2, submits that the complaint is has been filed by the opposite party number 2 against the petitioner, which is not in conformity with the judgment of the Supreme Court in the matter of Priyanka Srivastava.
Priyanka Srivastava and another was the state of Uttar Pradesh, 2015.
Give it, Mr.
2015, volume 6, that is there in paragraph 14.
At this stage, I am not entering into the merits of the case, only on the aforementioned question as to whether the complaint has been filed in conformity with the judgment of the Supreme Court or not.
Mandatory requirements stated in
issue notice. Yes.
27.
Here in the CRLM's application, Your Lordship, I pray for set aside of the order dated 6/1/25 under annexure 1, my lord. It is arising out of a complaint case, that is 138 NI Act case, my lord, regarding compensation, my lord. My lord,
143.
148.
Interim compensation. Acha, 148.
148. My lord, only 2 installments I have to pay 26,000 each. But in between, my lord, 2 installments. There are 3 installments there. First installment I have paid it. But next 2 installments I could not pay because of.
Where is the order? Let us see. We'll find out.
My lord, page 9, my lord.
9, huh?
Page 9 and 10, my lord. Completely.
15%. What is this on Procedural for the record and so on, so on, so. This court by order, it's allowed the petition filed of the appellant. Payment of 15% of compensation amount, huh?
Yes, my lord.
Installment. And further directed the appellant to deposit 15% of the compensation amount, 78,000.
Yes, my lord.
In 3 installments.
26,000 I have already paid.
Appellant is deposited the first installment so and so.
Thereafter, the appellant has neither deposited the second installment of 26,000 on 23/12/24 and nor deposit third installment.
What do you want now? See, there is an order.
No.
See, there is an order of interim compensation.
Yes.
You partly complied, partly you don't want to.
No, my lord. In between, I got my lord brain stroke. My lord, I have annexed it. My
Okay,
lord.
now how much time you need?
3 months time, my lord.
I'll have to.
60 days. Yours and
Brain stroke, where have you said brain stroke medical document?
Page 20, 21, there is annexed to the document.
Okay.
Regarding health condition of the appellant.
3 months. One installment you give in 1 month and the other installment I will.
2 months.
Because see, this order was passed, I tell you, the order was passed when?
6/1/25, my lord.
6/1/2025.
Yes,
Where is the medical document?
my lord, Annex 3, 19 and 22.
Petitioner is agreed by the order dated 6/1/2025, whereby the additional district and session judge Kujongo in criminal appeal number 16 of 2018 directed 2018, huh?
My lord.
2018 directed the petitioner to pay 15% of the 15% of what? 15% of
compensation amount.
15% of compensation amount in 3 installments. 3 installments. The total compensation amount of 78,000 rupees was divided into 3 installments. The petitioner installment, the petitioner on 2/12/2024 made good the first installment. However, defaulted in making good the third and second installment. The appellate court rejected the prayer made by the petitioner for extending the time to pay the second and third installment and recall the bail.
Yes, my lord.
And recall the bail granted to the appellant. The petitioner being the appellant, criminal appeal number 16 of 2018 is agreed by the same and has filed the present petition. Relying upon the medical documents placed at Annex 3, the counsel for the petitioner submits that the petitioner in the meantime has suffered a brain stroke. Therefore, he could not pay the compensation amount as directed by the appellate court. Is directed by the additional so and so by the impugnant. He submits that he is ready and willing to make good the entire payment. However, he seeks 3 months further time further time. In view of the medical condition, the petitioner is undergoing at the present. The prayer made by the petitioner sounds genuine. Hence, I'm inclined to allow the prayer and extend the time for making good the installment as fixed by the appellate court, and allow the petitioner to make good the two installment within 2 months. Within 2 months.
Within, my lord?
2 months.
2 months. Obliged.
I'll issue, and I'm this court is alive to the fact that the present matter is allowed without issuing notice to the opposite party. Issuing notice to the opposite party would further delay the appeal. Rather, in the best interest of both the parties, it would be expedient that the petitioner should be allowed time to make good, allowed to pay the compensation amount as directed by the appellate court, which is the stipulated time frame.
Obliged, my lord.
I issue notice, then you notice will go and it will take 3 months.
No.
Unnecessary. It's better
Obliged,
that you
obliged.
pay it in 2 months and finish it up.
Obliged.
Ex parte order I should not make, but the real problem is I suppose I will issue notice. Process will go, and by that time 2-3 months will go, and thereafter again same order will be passed. So better that is yes.
28. Petitioner challenges the order dated 28/1/2025, my lord, by the annexure 3 at page 24, relevant, my lord.
Annexure 3, NBW.
Yes, ma'am.
You are on bail.
My lord.
The present activities are under 138 is active. In citizen complaint is by the police station part. In police station, the present is not in bail. After acquittal, whatever the individual issue on the bail.
No. After the acquittal, the police has filed the petition that he is an absconder. He has been attending the court in the same SDGM court.
What is the FIR? 420.
Yes, ma'am.
Same 138.
Yes, ma'am. Annexure 2 is the acquittal order I have filed.
138 is acquittal.
What happened to the appeal?
Appeal not filed.
You not filed appeal against the acquitted.
Yes, ma'am.
Acquitted. Okay.
Annexure 2.
Petitioner, the opposite party number 2 is there.
Yes.
Opposite party number 2 initiated 1cc case number 85 of 2017 against the petitioner for alleged commission of offence under section 138 and 8.
Yes.
The petitioner was put to trial, and eventually the judicial magistrate first class Atagoda, by its judgment dated 26/12/2024, acquitted the petitioner from the charges under section 138 and 8. On the self-same ground, on the self-same allegation, the opposite party had also initiated a criminal case, being Atagoda PS case number 240 for 2017 for offence under section 420 IPC. In the said case, the charge sheet has been filed. The petitioner was shown as an absconder.
No, charge sheet has not been filed.
Charge sheet has been filed. And the petitioner has been shown as an absconder. And on the request of the IO, NBW has been issued by the order dated 28/1/2025 by learned SCJM Atagoda. The petitioner is agreed by the same. The learned counsel of the petitioner submits that on the self-same ground, 2 proceedings were initiated, namely a complaint under section 138 NIA and an FIR. FIR being FIR number so and so. The petitioner has already been acquitted in the complaint case. The petitioner has been diligently appearing before the trial court during the proceeding before the SCGM court of SCGM in ICC 1cc case number 85 of 2017. Therefore, the representation of the petitioner, representation of the IO before the trial court that the petitioner is absconding is completely false. Be that as it may, since the NBW has been issued, I am inclined to was the same, subject to the petitioner appearing before the trial court on or before, on or before 30th of April, 30th of April, okay? And resort to the remedy available to him. Yes, allowed.
made between the parties. Plus allegation is under section 419, 420, 506, 34 of the IPC, Your Lordship. Your Lordship, can I glance to
I'll
page?
issue notice. I'll issue notice. Case is a 420 and all, interstate dispute between them.
32 also. Sir.
Are you a builder?
No, Millers.
No, no. Here is the case.
Individual
Millers.
It's a question. It
is an isolated incident, or you have collected money for many people?
From
Two cases has been insured. Two cases, Millers. This is another.
You have taken from two people.
Plus, from some people, Millers, but two cases.
How
have
many
been-
people? Oh, that's the problem. It's not
Millers.
no more a interstate dispute. It is now a wider dispute. Cheating many people.
Not many people, Your Lordship. Only two to four Millers.
Two complaints have come, but how many people you have cheated? That's the important thing. Merely because two complaints has come doesn't mean that there are two cases only. I issue notice. Just see the status. Land Council for the state to file the status report. Let us see how many. Yes.
32 also said.
32 same, Millers.
32 also same. These are tag कर दियो. Tag करके yes. Status report. Let the status report come. If you have done more than two, then no question of question.
What happened? The informant has filed affidavit here saying that we have already received that.
Maybe see, we don't know. The police has to investigate.
Yes.
And then he has to refund money to all. Then only the question of question arises. Let's see. Yes.
32 same, Millers.
32 same.
31.
Both the matters should be tagged together. No, the 31 and 32.
Plus
30 and 30.
30 and 32. Oh, same person.
Same.
30, 32, same order, tagged. Yes. 31.
31, let it come 2 weeks after Mirror's file is somewhere misplaced.
File misplaced. Okay. And consider that he has misplaced the file and it 2 weeks time to reconstruct the same. Release the matter after 3 weeks. Yes.
33.
500 वर madam. 500 वर.
Password.
34.
34 matrimonial dispute.
My page, Your Lordship. 34 is the application for quashing of the affair, my lord.
Okay, I'll issue notice 498.
498.
Yes.
The informant has also filed a CP also, that has also been dismissed. So after dismissal of the CP, out of frustration, she came up with the affair against the petitioner. CP
No.
is the.
Now it is settled or not? Not settled. Is there any chance of settlement?
So
Why?
the marriage was solemnized in 2022.
Yes.
So they lived together for hardly a month.
But it's all right.
After that, she left the husband and went to the place.
She has filed the CP which has been dismissed.
She could not prove the allegation.
So now you are emboldened not to settle. But you have to settle, you have to pay something and settle it.
Both of them are school teachers, high school teachers.
But some alimony or something. Anyway, we'll issue notice. Let's see. Issue notice.
Okay.
So. Oh.
36.
Yes. 36, Mr. Vishal. Yes. Passing.
Vigilance case.
Let the counsel for the Mr. Maharana, let the counsel for the vigilance submits that copy of the petition has not been supplied. Advance copy is not supplied. Let the counsel for the petitioner to supply the copy for the petition, advance copy of the petition, please the matter.
37.
37 is the Belgium matter.
Belgium matter, Lordship.
Belgium matter. NBW was issued on the 7/11/2024. Earlier, the bail has been granted by this court and the order has been modified.
Date, you give me the date.
7/11/2024.
The NBW.
NBW.
Bail.
Bail.
Bail was granted on 26/10/2022.
Okay, 500. Yes, next.
38.
Obliged.
Can taken up next week, madam.
Yeah. For the yes.
Can be taken up next week. Mr. Dhawal is out
Is it
of court.
Belgium or what?
No, madam, not Belgium. Challenging the.
What are you seeking, sir?
Challenge the
Quashing.
affair, quashing of affair.
Judgment court.
39.
May it please your lordship. Lordship is the matter, is a similar matter as in CRLMC number 4926 of 2024. The lordship has passed an order on dated 27/1/2025 for the interim compensation to be 10% as of 20%.
In all the matters.
My lord.
First matter, what is the compensation amount?
Your lordship, first matter is of 1 lakh rupees compensation. The compensation amount is 20,000, my lord.
The check amount is?
Second amount is 50,000 and the compensation amount is 10,000, my lord.
Yes.
And the
That
third
reduced
is
to-
and the third amount is rupees 2 lakhs and the compensation amount is 40,000, my lords. And the fourth matter is of rupees 6,50,000 and the compensation amount is 1,30,000, my lords.
How many cases you have?
5.
5 cases.
Including that.
In this case, you cannot go.
Including that. 5.
6 cases total.
Total 5, my lords.
No.
That.
Here, how many cases now?
4, my lord.
4 cases, and this is 5th one. Complainant is same.
My lord. Accused also same, my lord.
But take out notice, huh? Take out notice, and I list it on 28. Take out notice.
The lordship grant a stay for till then.
No, take 28. You take it. What stay? 28. I'm putting it on 28th of this month. No, Land Council for the petitioner submits that 5 138 cases, 5 different 138 cases, 5 different complaints under section 138 NI8 has been initiated by the opposite party against the present petitioner. In one of the cases, the petitioner has approached this court against the impugn order, whereby the petitioner was directed to deposit 20% of the check amount as interim compensation under section 143 capital A of NI Act. This court, while allowing the CRLMC number 4926 of 2024, by its order dated 27/1/2025, directed the petitioners to deposit 10% of the check amount as an interim compensation, and interim compensation besides the direction to the trial court to proceed with the matter, proceed with the trial of the case, proceed with the trial of the case. He seeks a similar direction in the present 4 cases. Good record, all the present 4 cases.
Your lordship.
Issue notice to the opposite party. Release the matter on 28th of March. 28th of March. The petitioner to file requisites during the course of the day. You file.
The lordship, the time we may file the time petition before the learned court time petition may allow.
28th I am keeping what time petition? 28th I am keeping because I will allow this. I can't allow ex parte, therefore I am doing it. Formal notice I am issuing. Come on 28th I will allow. The same order I will pass. But formally notice has to go. Otherwise he will complain in all the cases, 5 cases, ex parte orders are being made. So that is the reason I am issuing notice. File the process during the course of the day. Okay. I will allow on 28th. Same order I will pass. Okay. Yes. 40.
Private dispute.
Okay. Pass over. Yeah. 40.
41.
May reason.
Yes, sir.
The petition has sought for quashing of the order of cognizance, so also the entire criminal proceeding on the ground that the prosecution was instituted in the year 2010.
In the
Yes.
2010, my lord, by virtue of the order of this honorable court, he was released on bail. In 2015, the charge sheet was submitted. When the offense was committed, the petitioner was a college student of 19 years. Now, my lord, he has been staying abroad, serving there. The due to pendency of this case since 2010, that is for last more than 15 years.
What are the allegations? It's only 420.
420 only allegation.
What are the allegations against?
The allegation is that the FIR, the Lordship have a glance annexure 1.
You tell me, I
The
did not see.
informant gave, the informant alleged that he came to know that from his bank account, purchase has been made amounting rupees 38,000 some odd.
30 lakhs.
30 lakhs.
30 lakhs, 2,083.
30 lakhs, 38 na.
30
That is
lakhs.
the charge sheet, your lordship kindly see page 42. The charge sheet.
30 lakhs.
No, sir,
40?
42.
42, yes.
That on 7/5 he.
Oh, 30 lakhs, 22. 280.
Was withdrawn from his bank account, sir.
It's a huge amount.
38 actually. It's wrongly it has been mentioned. FIR computer.
Where from you get 38?
In the FIR manner.
FIR, after investigation it was found. It is 30 lakhs. This is very specific.
And the petitioner has been declared absconder. Till date he has.
If this is the
No,
conduct.
it is not correct, my lord.
Your lordship said.
I was released on bail in 2010.
But why don't you go and appear in the court? The delay is attributable to you.
No, my lord, nothing. It is there, the laches on the part of the prosecution.
See, charge sheet is filed showing you as an absconder.
But I was released on bail in 2010.
That's right. In 2010, 2015, after release on bail,
The charge sheet was submitted in 2015. 5 years after the incident, the charge sheet was submitted.
Thereafter, what happened?
Thereafter, the prosecution has not proceeded.
Because you are absconding. Charge sheet is filed in your absence.
No, that they have shown.
You go and appear.
All through I am there, my lord. All through I am appearing.
All through, sir, you got 2010, you got the bail.
Yes.
It is a fraud of 30 lakhs from somebody's account.
But again, it is not correct. Perhaps wrongly they have mentioned.
Whether you say 38, the charge sheet say 30.
Only 38,000, my lord. To purchase only 38,000.
What should I believe? The police investigation?
No, that true, my lord, but it was not his within.
And 2010 you got the bail.
In his account.
You didn't. Maybe you might not have cooperated. Therefore, 2015 the charge sheet is filed showing you as an absconder. Thereafter, nothing is moving because you are working somewhere in abroad.
No, my lord, that is.
That is the story I am getting from your own petition.
Your lordship call it next week. I will give that.
No, that's better idea.
Dispute amount.
Give me clear picture. Give me clear picture. But from your petition, this is what I gathered.
Yes, from petition, Malit is 38,000.
I'll put it next week. It will otherwise I'll have
Yes,
to,
yes.
I'll have to simply dismiss it otherwise. From your petition, reading of the petition, give that impression. 2010 you got the bail.
Yes.
Thereafter you have not cooperated. 2015 charge sheet is filed showing you as an absconder. Thereafter you have vanished somewhere. Now you are working somewhere in other country.
After releasing on bail in 2010, there was no occasion in sitting over the matter for last 5 years.
Then why the police
after releasing on bail, but after releasing on bail, I should not have been shown as absconder because I have been
if you
on
don't
bail.
see when the charge sheet is filed, you
not
don't
the
go.
case of the prosecution that I did not appear and the warrant
It
was
appears
issued.
after getting the bail, you forget that there is a case against you.
No, my lord, I was appearing in through,
And police
through my
was
counsel. I was
police have
appearing.
been searching you, and ultimately after 5 years the charge sheet is filed showing you as an absconder.
After
You clarify, otherwise if I go by this petition, then I'll have to dismiss. If you
I
clarify,
verify that amount only.
that's a better idea. After 2 weeks, huh? After 2 weeks.
The date may be fixed too. Because
Yes.
42. 42 matrimonial dispute.
Yes. 498A.
498.
Issue notice. Huh? Issue notice. Yes.
43.
My lord, I'm appearing on behalf of my senior H.N. Mahapatra. I pray this court to adjourn this matter up to 2 weeks.
No, I'm going to give you relief. If you don't want to take, it's all right.
So 42.
I'm issuing notice, madam.
Yes.
It's a matrimonial dispute.
Yes, my lord.
File process, let us see.
My
If she
lord.
comes, we'll try to find out something.
My lord.
Okay.
43.
My lordship, petitioner wants to make a direction for recalling of some important questions. PW1 informant.
PW?
1 informant. Page, my lordship, 10 to 13. The question
Bookso
is
is there.
6 bookso.
Where is the charge sheet?
No, he has not annexed that charge. No charge sheet has been annexed.
My
What
lordship,
are the offences, sir?
offense, sir, 363 in affair, latter 363, 376 and 376 366 of IPC related to section 6 of POCSO Act.
Yes.
Petitioner was on bail.
Yes.
It's my lord,
Where is your application under 311? Yes, I
my
got
lord,
it. What are the
annexure 1
questions?
page 8.
Relevant questions, page 9.
What are these questions? Just see the first two questions.
Particular question to be asked. Sudhir Naik has never kidnapped you at any point of time. Point 2, Sudhir Naik has never kept physical relationship with you.
No. These questions. The child witness, what is the age of the witness? What is the age of the witness? Is 17. I know. You have to lead defense evidence, but you can't recall the child witness repeatedly like this. And see the questions, kind of question. Sudhir Naik has never kidnapped you at gunpoint. This is the question you want to put to the child witness. Sudhir Naik has never kept physical sexual relationship with you. This is the kind of question you want to ask the child witness. Petitioner is agreed by the order dated 4/12/2024, passed by learned
FTSC.
learned
FTSC.
Fast track FTSC Ungood in special bracket POCSO case number 11 of 2022, whereby his application, the petitioner's application under section 311 CrPC to recall PW1 has been turned down. Counsel for the petitioner has taken me to the application moved by the petitioner under section 311 and highlighted the questions, a schedule of questions, proposed questions to be put to the head witness. With the perusal of the questions, enumerated in the application reveals that the questions the learned counsel, Mr. Vishwal, learned counsel for the petition state submits that the child witness was examined by the prosecution on 2nd November 2022, and she was subjected to cross-examination, lengthy cross-examination on two different occasions. Therefore, recalling the same witness at the belated stage is being easily opposed by the state counsel. Section 33 bracket 5 of POCSO Act prohibits, statutorily prohibits to recall the child witnesses repeatedly for cross-examination or cross-examination. Moreover, the questions sought to be put to the witnesses are not relevant or not relevant as the same questions that have been indirectly put to the witnesses, already put to the witnesses. Regarding head to the information, I am not inclined to allow the income to interfere in the present matter. However, liberty is granted to the petitioner to lead the defense evidence if so advised in that with this observation, petition is disposed of. Yes, next.
45.
May I please, Madam? For non-taking of steps, my lord, in a complaint case, the learned magistrate has dismissed the complaint petition, my lord.
Yes.
That is the sole.
So many proceeding. What is the complaint?
The complaint case is under section 138 of the NI Act, my lord.
Why have you not taken steps?
Due to communication gap between my advocate and myself, my lord.
See, it was filed on 2019.
My lord, my lord.
Okay.
And it was dismissed on 2023.
For 3 years you have not taken any step.
My advocate did not.
Are you serious?
Yes, my advocate did not intimate me anything, my lord.
Check amount?
Check amount is, my lord, 10 lakhs, my lord.
I have to issue notice then. Issue notice. Opposite party number 2. Yes.
Obligation.
Let him come so that I will fix a date and I'll
Yes.
tell both of you to go and appear.
Yes.
Your service hassle will also go.
Yes.
In trial court.
Yes. Requisite by
tomorrow.
Yes. Obligation.
So both the things can be worked out.
Done here.
Yes.
46.
May I please, my lord, in this case, petitioner challenge the order of cognizance matter relating to matrimonial issue, my lord, between husband and wife.
Matrimonial issue?
My lord, notice.
Okay, issue notice, huh? Issue notice. Yes.
Obliged.
Yes.
47.
47, may I please you? The matter has been compromised between the
Compromise.
my lordship.
What are the offenses?
Offense is 363. My charge sheet is also filed. Both are married, my lordship. What is a present, my lordship?
The victim has married to the
My lordship.
Yes. What is the age of victim?
19 years, my lordship.
19.
My lordship.
Charge sheet has not been filed.
Charge sheet I have attached in the.
He should go and tell sorry and bring. That's all.
That is
to save your marriage. If you don't do, you try to be man enough to go to your father-in-law and tell sorry. You kidnap a girl and marry it, but you don't want to go to your father-in-law.
She has given in own will, own will.
I am talking about you. Go to your father-in-law's house, tell sorry that you say that I am married, and ask him to come here. Okay. Yeah. Surrender. That's the only way. Nothing else. They are young people that 22, 19.
Now 25
Let them settle what you can't do. You know. Yes. Yes. Next. Right.
The order of rejection of the petition number 205, that is order annexure 7. The Lordship may kindly turn to page 27.
27.
Yes.
Yes.
The reasoning given while rejecting 205. My lord, it is arising out of a NI Act. I have filed a petition under 205 to dispense with my personal appearance on each and every day because I am staying at Baleshwar and having 2 small children. And my wife is working there as a manager in the Punjab National Bank and my
You have to appear in which Cuttack?
Cuttack.
Through VC you appear?
My lord, I have appeared and filed 205 petition that on each and every day my personal appearance may be dispensed with.
No. As and when required physical presence, you go. And the rest of the day you appear through VC. As simple as that.
No, my lord, my submission is 205 petition. My lord, this is this is arising out of NI Act. And I have stated in detail what is the problem of mine in appearing each and every day before the court. My lord, that has not been taken note of what has happened. My lord, order has been passed. Care record reveals that the reason so cited by the accused is not supported by any document that wife of accused is serving at Balasore as he has taken.
What are you doing?
My lord, I am a business contractor. My wife is a manager in the Punjab National Bank. And I
What
have
is the check amount?
4 lakhs.
The contractor, your wife is working in bank. Why don't you pay?
My
I'll
lord,
send it to
provided
mediation
I have-
5205. Everything is over.
Provided I have taken, he was working under me. He has taken the check and he was looking after everything.
I'll issue notice. You make up your mind. You to pay the money.
My lord,
I'll issue notice simply.
my lord, your lordship may issue notice. Let it be decided, my lord, refer to the mediation. So
That's
that
what I'm saying.
let your lordship may, and your lordship may stay the further.
No, 138. I can't stay like this.
My lord, then I will be,
Right?
my lord,
Petition
it
is
has been,
agreed by
my
the
lord,
order dated.
may I
Oh,
submit?
one appearance or 2 appearance will not make a great difference to you.
My lord,
I'll put it after
my
after
lord,
2 weeks.
13, my lord, 13 months old, my daughter.
That's right, but what will happen? NBW will be issued. I'll cancel it. I'll cancel it.
Again, I have to run to your lordship.
They're not going to hang you.
No,
Right.
again, I have to run.
Petitioner is agreed by the order dated 1/3/2025. I'll give you that liberty. I'm sending it to mediation center and move an application for adjournment meanwhile and explore the possibility of settlement. Petitioner is agreed by the order dated 1/3/2025 passed by learned JMFC 3 Cognizance taking Cuttack in 1cc case number 49 up to 2024 initiated by the opposite party against the petitioner for alleged commission of offence under section 138 NI Act. The application moved by the petitioner under section 205 CrPC has been turned down by the imbue order. Land Council for Mr. Sujata Jana, Land Council for the petitioner submits that the petitioner is facing a genuine problem domestically. The petitioner's parents are ailing, and the wife of the petitioner is serving in a bank. Therefore, he has to be there in the house throughout for taking care of his parents. That's the reason he has
And
moved,
also infant
he had moved an
children.
application seeking exemption from personal appearance before the AJMFC Cuttack court, being the resident of Balasore, The trial court has rejected the application. Issue notice to opposite party number 2, returnable on so. Regard being had to the fact that the check amount is 4 lakhs. I'm of the venture review that the party can explore an out of court settlement as well. Therefore, I will send it to Balasore Mediation Center. Balasore Mediation Center, the mediation.
Balasore,
So. And in the meantime, petitioner is at liberty to move application before the trial court. So seeking adjournment during the process of mediation. The awaiting mediation report, lease the matter after 3 weeks,
Hello,
4 weeks.
my lord, petition, the case has been fixed to tomorrow, so that my
I move application. I will. Yes.
Oblige.
Yes.
Urgent copy of your lordship.
Yes.
49.
14, may I please, your lordship?
Yes, madam.
The present appellant is convicted on PC Act for 13 clause 2 and 13(1).
Sentence.
Sentence 3 years, my lord.
3 years.
IA for
Each count.
Yes. Yes, Mr. Das.
Yes, on 3 years on each count, 409 and 13(1)C.
Okay, it's all right. Appeal admitted, bail granted, the realization of fine is state. Okay. Yes, TRC called for, and Mr. Das appealed. That's very important. Free copy also.
Obliged, ma'am.
Yes.
I beg your lordship's pardon, Lord, I need some time for preparation. You have put an adverse tax to me, so I need some action.
Is a candidate admission.
Reports now question that in the event the date of the complainant and the going was whether the trial court should stop for looking at all the metrics and records. Because when they, on Supreme Court, there that will be.
You have already shown me a judgment which is creating problem for him. That's the reason he's asking for time.
They are not giving all the statements of all the witnesses. Besides, I raised another. Let him examine.
Yes.
Overall, the witness not fully supported prosecution with regard to factor of demand and acceptance. The magistrate witness at page 41 also proves the prior demands and also that he calculated the numbers of the recovered money and found it to be carried with the preparatory reports. And the TLO will also prove the factor of recovery at page 43. I think very kind words.
Very fine. I'll just simply adjourn on your request.
Besides, with the lordship's permission, besides there is a point that the petitioner was not in a position to forbear the award. That means, with my humble submission, even his abuse his position of being a staff of the appeal can come within the scope. That is, therefore I need some. Yes. That's what I need some.
Section 7 is meant for this kind of situation only.
Then it could be scaled
You
down.
may not be a public servant, but if you give an impression that I'll get your work done and get the money, then also 7.
Then 13 will go. Then I stand for trial for section 7. And I need some exercise.
What is the stage now? Your application for discharge.
That against the discharge application, that is yet to be.
Okay, simply adjourn.
I make an that's your lordship. That already is there.
Already there.
One day.
Arrangement.
That already.
Okay, that arrangement, earlier arrangement, dated 16/1/2025 shall continue.
Make an application on the date. That's one.
Yes, that's, I am continuing that arrangement.
Next step. Page 8 for the amended state of the state. The said witness never wished for the statements and acquisitions never had any demand to complaint. Absolutely contrary, bristling with contradictions. These are very. Besides, another.
That sentence is copy paste in all the petition. Don't worry.
I raised the point that the.
There is no iota of evidence. There is no, the prosecution witness have not whispered. All these things are pat words used in this side.
All these statements of the witness very nicely. The pertinent point I raised that person is not in a position to forbear the award. That's it. That's a matter.
Okay, we'll see. We'll examine that. Okay. Yes.
51.
Yes.
My lord, this is a Belgium matter, my lord.
Yes. Tell me the dates.
Imbue was issued on 23/9/24, my lord.
Yes. Bail date.
Bail date, unfortunately, I could not collected the bail date, but he was on bail.
500. Yes. Next.
52.
Belgium matter, my lord. First appearance. Belgium matter, lordship, and on the date of 18/12/2024, NBW was issued, lordship.
Bail date.
My lord.
When you got the bail? Yes.
My lord,
what I-
7/7/2023.
Give me the dates. Why are you dealing?
7/7/2024.
24. Okay. 24 and 500. Okay.
53.
Belgium man, so it is on 21/12/21, he was on release on bail. Thereafter on 61 did not take steps.
25 or 500. Yes. 500 each. Yes.
54.
54 Belgium matter Imbue issued on 17/1/25. Bail, no steps has been taken. Earlier occasion, the petition was on bail, lordship.
Sorry?
No steps has been taken on behalf of the petition.
Bail, you give me the date when you got the bail. Huh?
Bail thila, say order.
Tell me the date, sir.
Exact date tab na hai.
Date no. NBW issue for you. 500. No? 17/1/2025. Yes. Yes.
55.
Belgium matter, lordship, bail on 12 June 2017 and warrant on 28/2/2025.
500.
56.
My lord, this is a Belgium matter. Bail granted on 21/6/2006. NBW issued on 15/2/2023.
Okay, 500. Yes.
57.
And the petition has been released on bail on 21/9/2016 and a warrant issued on 18/7/2022.
22.
My lord.
Okay. 1000. Yes.
58.
In the 138 matter,
at the stage of active statement, the petitioner's package advocate here, it could not travel to Bhavanipatna. So the learned court has issued NBW.
Okay.
That may be recalled and
The petitioner is facing the criminal prosecution initiated by opposite party under section 138 NIA. When the matter was fixed for recording of statement under section 330 CrPC, the petitioner could not appear in the court, leading to the issuance of NBW on
18
2025, 500. Yes.
59.
obliging.
Yes. Service.
A review matter. The endowment matter.
Yes.
It is an endowment matter.
Who is appearing for the opposite side?
Mr. Ramjas.
Yes. Yes, sir. Review of which judgment you are seeking?
My lord, Annexure 1, order
Yes.
dated 16/5/2014.
Yes. Yes.
After
What
that,
happened?
he filed a writ appeal.
Yes.
Though it was not required to file because it is not permissible, it is not maintainable. Under 227, order against under 227, writ appeal is not permissible. But he being wrongly advised, filed. After 3 years, he withdrew it.
Who? The opposite side number?
This petitioner, review petitioner.
Actually, you have.
And he approached the Honorable Supreme Court, my lord.
Yes.
Honorable Supreme Court said, your allegation is that you have not been heard. Then you file review in the.
No.
It cannot be.
Where is that Supreme Court order?
Yes,
Supreme Court.
Annexure 2, page 13. Factor 26.
Yes.
Jaha observe kale, ebo order kale review petition. By way of review petition.
Yes.
That is how the law matter has come to your lordship.
Permission is granted anyway. The review is
Yes.
on the basis of the permission by Supreme Court. Yes. Tell me now how the review is maintainable. What are the grounds?
I have explained, your
Whether
lordship.
it is coming under order 47, any exception of order 47. What are the
Your
other?
lordship may kindly see the prayer of the writ application first.
Yes. Prayer of the writ application.
Ma'am.
Yes. Yes. Yes.
Pass Annexure 16 million. The only prayer to pass the Annexure 16.
What is Annexure
That-
16?
Annexure 16. Page 76, your lords may see. The writ application.
Yes.
Wherein the additional commissioner has declared. Page 76, your lords. That is. The
Page 77, come to 77.
the relevant portion is page 81, where he has declared.
Yes.
Findings. He has given the findings.
Yes.
81. The institution is a, so from my inquiry, it is ascertained that the institution is a public temple. The ancestors of the person in minority are not in founder of the temple. The case of the way of 51 declaring Vadunath Das and Sukadeva Das has no binding effect on general public and the endowment department. The current person in management Sukadeva Das is not the hereditary trustee of the temple. In view of this, non-hereditary trust boards should be formed under section 27 of its Act. This has been challenged in the writ petition. Your lordship, may
The report may be submitted. Yes.
I narrate the background of the case?
No, you tell me what happened thereafter.
Thereafter, he has filed the writ, and writ has been allowed in one date, first date.
Show me.
Yes, order your lordship, see. I have annexed in the. Essentially, it has been allowed because it has been passed. What prayer was made, that has been allowed. Annexed 1.
What are the direction?
I have got it, order. I have annexed it in the review petition.
It is only the remand of order. It's a kind of remand order. Come to the page 12 of your review petition.
Not
In
remand.
view of the
sir.
above submission, the order dated so and so passed by dated so and so is quashed. It is directed that in the event of a proceeding under section 41 of
Exactly.
51
In the
Act,
past
filed
date,
in respect of the institution, the same shall be considered by the later additional and so and so on its own merit and disposed of in accordance with law without being influenced by the observation made by so and so.
Oh, this is the best. That's why I was saying I am submitting the background of the case. In another,
No, background, I need not hear the full complete petition.
it is the
In the review petition, whether any ground as contemplated under section 47 is made out or not, that is the thing. Yes.
Submission made, just submission made, it has been allowed in the one date without hearing. Your lordship may come to the previous page. Just a minute. Previous page.
Even if it is not heard, it's not a ground for
He has been heard.
heard the
And
land
counsel
counsel
for
petitioner
opinion
may start and let counsel appearing for opposite party.
Yes.
I got it. Right.
Yes. After hearing both.
What is wrong in that review order? It is only a remand kind of order.
Yes.
You move application under
section 41.
41 and it will be decided on it.
order 20.
That's the reason Supreme Court has not interfered.
On 27, it has been decided on
27, no jurisdiction. It is an administrative.
operate as a res judicata.
No.
In another writ application, the order was passed.
You raise, if it is barred by res judicata,
Yes.
when the proceeding starts, you raise this.
Yes.
And that will be dealt with in that. Where is the question of review?
That is the observation.
It is the outcome of another writ petition, my lord. Your lordship have to see the another writ application. Direction was made in 2000 in another year. That's why your lordship should know the background of the case.
In the review, I can't hear everything, sir. You have to make out a case
No, he has
within the
suppressed.
exception of 47.
Yes, I am submitting. He has suppressed.
What is it?
Yes.
What's suppressed?
He has suppressed the matter that his application for declaring the it has a private temple, a private institution has been dismissed, has been rejected by the authority. He has that suppressed. Yes, I saw the number.
Not go to that.
Where have you said that in review petition?
No, I have not given it chance.
In the review petition, where have you said that?
No, review petition that I have not been had. We have opportunity maybe.
That's precisely your ground. In the review, have you said that he has suppressed and all, and this document is necessary? Then you can come under the second exception of 47. You don't make out that case, then what can I do? Discovery of a document or a document withheld by him, which was necessary to be adjudicated. At least you should come under that exception. Then only I can interfere. If you don't say anything in the review, what can I do? Your precise case is a particular document which has been withheld by him, and without giving you a opportunity of hearing, the writ petition was allowed. Your name is there, you are heard, all these things are all right. But this is a document which was withheld by them.
Yes.
And you can at least bring that in the purview of discovery of a new document, or it was available and it was not placed, something of that sort. So I can entertain the review.
Your lordship may give 1 week time. I will file that document.
Did you follow what I am trying to
Yes,
say?
yes. I will file that document.
That would be the precise case.
Yes, my lord.
Then only review.
The document is too important with
I would have dismissed the review by now, but since you got the liberty from the Supreme Court, I have to entertain. Therefore, I am entertaining. You tried this thing there in Supreme Court. Supreme Court didn't agree. So you withdrew with some liberty. Okay, that liberty you have to encase. There is no doubt about it. But you have to make out a case for it.
I will file that document, your lordship.
File the document and bring with that exception,
Yes,
saying that this is the document which was withheld by him.
Suppressed, yes.
I'll submit only 2 lines with the lordship.
Now let him do. He has to make out a case. Otherwise, I'm not with him today. I'm with you.
No. My lord, there is a judicial declaration 63 years by the commissioner that it is managed by Hale Tree Trustee. So many proceedings are filed. The assistant commissioner in this proceeding administrative inquiry in section 27, because the High Court has held you decide, has held that it is non-Hale Tree Trustee. They're very strange things, my lord.
But those documents were placed before the High Court or not?
Yes.
He says that many documents which is not placed.
Everything has been annexed.
Let us see. Let him make out a case. If these documents were not placed before the High Court and High Court passes an order
Yes.
without even issuing notice,
Yes,
on advance notice he might have appeared.
yes. No, he has appeared in caveat.
Notice was issued.
Yes, he has appeared in caveat.
Caveat.
Yes, he has appeared in caveat. Senior counsel, Mr. Vitas, he has appeared.
Okay, we'll see. That record is there. I will look into it.
Yes, your lordship may.
You please make out a case. Huh? Okay.
On chapter.
Yes.
60. Right. 60 is simple restoration of writ petition, my lord. It's a year of 2002, my lord, matter, agency. And bill file that has been dismissed on 29/6/15, my lord. Only
Delay, how much delay?
44 days, my lord. I have
Are you appearing?
I am appealing some of the opposite parties. That is appointment 3 and 10 to 14. There
This-
are so many opposite parties.
Where is that order for dismissing?
dismissed on 29/6/15 mile. I have filed on 11/8/15 mile.
Is there anything still left in the
Man, state at thila.
writ petition?
Writ thila.
नहीं रीट्रे कौन अच्छी की मेरिट अच्छी की रीट्रे
None of this
I understand sir whether रीट्रे को any merit is still there why should I restore if there is nothing in the matter
Yes, merit is there, my lord.
what is that treaty about
My lord, revisional commissioner's order has been challenged, my lord. It's a gochur government land, my lord. We are the villagers, and the opposite parties that grabbed that land, and now they have on taking the advantage of this dismissal. They have already so many sended has been made by the opposite party.
you see you have taken so many the writ petition was filed in 2002
2002, it's arising out of
Just see the-
OJC 147/2002.
and just see the writ petition is pending from 2002
My lord.
how many hearing has been given opportunities given to you to take steps you have not taken steps dismissed
My lord, on that date, man, what happened? was-
not that it is not for presence steps are not taken just see the order
I'm submitting, my lord.
come to this order come to the order 29 order that is 29/6/2015 non appear on behalf of the petitioner
What happened?
at the time of call sufficient opportunity has been given to the petitioner therefore it appears that the petitioner have no interest to pursue previous order just see
What happened, my lord? At that time, list subsequently appointed advocates.
don't tell that see metro was listed on 11/5/2015 before that 9/12/2014 before that again it was listed on 17/7/2013
No,
continuously the matter is listed
subsequently, we have.
and you are directed to take steps for publication under order 5
Yes, yes, I have-
rule 20 have you taken
Have a glance at 60 noting, my lord.
have you taken the steps
My lord. I've taken some.
order 5 rule 20 steps
In the writ petition.
in the writ petition
Read petition.
have you taken
Yes, man. No, paper publication.
have you done it
Yes.
where is that
It is also related to OJC 6235/2002. In that,
you show me the paper publication you have done now. Which newspaper?
Samaj.
Huh? Samaj. Yes, yes, sir. I'll put some cost. Restore it. Huh? Right off.
ଅଛି କିନ୍ତୁ ସେ କାଗଜଟା ସକାଳେ ଦେଖିଥିଲି ମୁଁ ଆଉ ପାଉନି
I've seen it. I've seen it. Same application suffers. I suppose delay of 44 days.
44 days only.
Delay of 44 days.
Now we are the subsequent
For the
lawyers.
reason stated in the application, the same is allowed, subject to petitioner paying a cost of 10,000 rupees to the opposite party. You completely, no, 10,000, I'm very minimum, I'm saying, give it 10,000. The CM appeal, CM appeal, the writ OJC number 6147 of 2002 was dismissed for non-prosecution on 29/6/2015. While the matter was heard by the writ court on 9/12/2014, the single judge of this court recorded that the prayer for publication of notice under Order 5, Rule 20 CPC in respect of opposite party number 2 and 5 was allowed, and the petitioner was directed to take necessary steps in that regard. It is found from the record that the petitioner has indeed taken steps to serve opposite party number 2 to 5 by substituted service. Subsequent thereto, the matter was listed on 11/5/2015. The petitioner did not appear before the court, and thereafter again on 29/6/2015, petitioner remained absent. Therefore, the writ petition was dismissed for non-prosecution. Agreed by the same, the present petitioner has filed CMA application, application number 515 of 2015. Which although 15, which suffers a delay of 44 days. The present petition has been pending since 11/8/2015. The counsel for the petitioner submits that the writ petition, which was dismissed for non-prosecution, deserves merit, and hence he seeks for restoration of the same on the ground stated in the application. Regard being head to the submission made at the bar and the reasons assigned for non-presence of the petitioner on the on 29 so and so, the same is allowed. The order dated so and so is set aside. The writ petition so and so is restored to its original file. Subject to petitioner paying the cost as stated above. 10,000 cost you take.
Status quo to be maintained.
I am restoring. That means everything will be restored. Yes. In the original file, I have said original file. Yes.
Your Lordship, this is Criminal Appeal 519 of 2009.
Yes.
This matter has already been argued by Senior Counsel Mr. Palit. So, Your Lordship, I'll be submitting this.
What do you want?
Filing this written notice.
Give it. Tag kar deta. Written note of submission. Give it. Okay.
So I will talk with, in between I will talk with the victim's
I'll
father.
just keep 44 killing.
47 Malsi. Interim.
We'll see, yes.
Take part in item 79. I pray, my lord, possible for the day 79.
Okay.
Any day, lordship. Oblige.
79 added, okay. Yes, start.
Item 7.
Yes.
Paper 1 with time, lordship.
On request. Yes.
Item 33.
May I please, your lordship? Here,
Yes.
my lord, petitioner has filed this 482 application for quashing of the proceeding that the GR case arising out of a PS case under section 498A, 506 IPC and 4 DP Act. My lord, the marriage was solemnized in the year 2016.
I'll issue notice 498A.
498. issue notice. And also, my lord, I pray for stay further proceeding because there are two proceedings pending before this honorable court. One RPFM and MATA. In spite of several notice several times, and if say valid service of the notice, he has never appeared.
That is a good reason not to give his stay. He's not bothered about the cases he has
because I
initiated.
still
So don't be sad.
what is
He's not going to do anything.
my difficulty is, my lord, I am a Gramo Rojugar Seva. I am serving on consolidated salary 12,900.
What is happening in the marriage front? Whether divorce has been granted to you?
No, my lord, that I have challenged before. I have filed a restitution application that was dismissed. Then she prayed for maintenance. Then I have challenged that order. Still, I am paying 5,000. She is a working lady working as a ANM in a government hospital.
Issue notice. Meanwhile, let him move application. What is the stage?
Stage. Well, this is the only charge sheet has filed and Cognizance has
Then
been
what,
taken.
nothing is happening.
Cognizance
Let
is-
the charge be frame at least. Why should I stay like this? Let charge is
Stay
frame.
like I said, 3 proceeding रे मैं बहुत हराना करছি। प्रत्येक date रे पढ़ुଛି सेटा असुविधा होଉଛି मते। So only for the time being till she appears.
You have chosen to marry her. What to do?
She is a quarrelsome lady. That's why she has one after another
Application.
stay of mother.
Yes.
Item 40.
Oblige. 40. Yes.
My lord, I am appearing for the petitioner. Kindly to be taken up tomorrow.
Not tomorrow, madam. If you want to argue, argue. Otherwise, it will go to May end or June
Tomorrow.
on the request of land council for the petitioner. Adjourn. Yes. I have adjourned it. Huh? We'll give it. Yes.
Oblige.
61.
May I please, my lord. Suit for petition of the year 99, my lord.
Yes.
It was passed and considerable 35 respondents. Now it has come to 50, my lord.
Yes.
It was passed expertise against few and on contest against most of them. The opposite party number 1, against whom the decree was passed expertise, preliminary decree was passed. He appeared in the final decree. He appeared in the execution case. There was delivery of possession. And now, then he filed an application under Order 9, Rule 30.
Who is appearing in this matter? Of the other side?
Mr. Acharya, Tapas Acharya.
His name is there in leaf? Okay. Yes.
Then he, after delivery of possession, my lord, he filed an application under Order 9, Rule 13 for setting aside expertise. Trial court found that Order 9, Rule 13 condition that there has to be a sufficiency in
Cause.
or sufficient cause or non-service of summons. Both the grounds were absent. On record, the court found that even now the delivery of possession has been granted. All the things have been discussed by the trial court. Then he filed an appeal before the appellate court. Appellate court said that the trial court wrongly focused on this issue. They should have seen that whether few of the because the another allegation that few of the respondents died. My specific argument that they have been substituted before the preliminary decree, and on that ground alone only the court allowed that saying Order 9 Rule 13 application.
Partition suit.
Partition suit, my lord. So 50 respondents. Notice have been sufficient because of the COVID period and thereafter notice sufficiently longer time. Now, my lord, delivery of possession has been granted to the opposite party number 1.
What is the what this respondent has got? Whether
he got as per that petition, there is equal shares.
Equal shares.
Yes.
What remains then?
Yes, after satisfaction decree. Yes.
Where is he's not there? 2018, this matter is pending. Call him if you, I can dispose it.
Because it's after notice, this has come for the first time. So I don't know.
Okay, none appears for opposite party despite entering appearance. And this matter is pending since 2018. In the interest of justice, last opportunity is granted to the respondent. Respondent to respond. Please see my transforms. Let us see.
Interim protection.
Interim. Is there any order already?
There. 937 and 20.
What interim protection you need?
For the proceeding in the trial court. Because after the decree was set aside, now if the trial court will proceed with the trial again.
No, see, this matter is pending since 2018.
It now posted to the day after, my lord.
No, it's all right, but 2018 onwards,
Yeah.
you have not obtained stay
No,
from
the
this court.
problem with what has happened.
In the absence, how can I give?
No, what has happened, I tell you, lordship. 2000, because they took some long time for sufficiency.
Whatever, and see, the
Then
matter is
thereafter-
pending since 2018. How can I give a stay in his absence?
Oh, he is supposed to, my lord.
Call him, you satisfy, I'll dispose it up right now.
We don't.
What to talk of stay, I'll dispose it up right now. But I can't give stay. See, the matter is pending since 2018. And he entered appearance merely because for some reason he might not be
Your lordship,
present.
day
Can't
after
do that.
tomorrow, I will inform him, my lord.
Not tomorrow, I'll just give you. Sorry. Huh?
I'll inform him. I'll
Inform him, bring him,
I'll
so we
locate
can
his
dispose
number
it up.
I'll telephone him.
See, this is a partition suit and
Yes, ma'am. I'll
not
locate his
everything.
number and telephone him. Your lordship will call me tomorrow.
Preliminary decree is already there.
Preliminary decree there, final decree there, execution is there, delivery possession is there.
Nothing. Now setting aside, no meaning.
That's right.
Yes, we'll see. Give it. Yes. Not Friday, next week. Next week. Next week. Huh?
Day after is posted.
No, next week. Day after.
Next week. Okay.
Day after I told you what.
Okay.
Yeah. Don't give any matter tomorrow unless it is very. Yes.
62.
62, my lord, the service has been returned unserved. But
Madam, I instructed that respond number 1 and 2 to file an wakalatnama.
1 and 2.
My lord.
in fact, my lord, they are the contesting parties.
What about the other?
Others, my lord, so far respondent number 7 is concerned, I will take instruction because the report is that seized
So
no more.
first steps to be taken by the petitioner for service on respondent 3 to 7. 3 to 7. So and so entered appearance for 1 and 2. 7 sufficient. 7 sufficient.
7,
3 to
my
6.
lord, I will
3
take
to 6.
steps.
3 to 6. Release the matter. Yes.
63.
63, may I please your lordship? But this application for restoration of CRLNC application which has been disposed of due to non-appearance, my lord.
Yes.
But last occasion, your lordship was pleased to issue notice. But my lordship, it was showing that
Who is appearing? Yes.
for my last occasion, yes.
Notice could not be issued.
Because of the
Due to the, my lord, deficit of fees which we have filed, my lord, on 18th of
Filed
February.
due to non-filing of the requisites in time. The service on opposite party number 2 could not be effected. The petitioner to take the first step to serve opposite party number 2. Release the matter. Yes.
Please, my lord.
64. 93 টা আগে অবশ্য তিনার রুলে মেনশন করবে item number 93 mentioning our mention করবে argument in fact that's a wrong mention if that come with appropriate time it will 41 support
But what can I do with mention and urgent?
this is already passed position
That's the problem. See, there should be some discipline in that side. I can't help it.
that's fine but your lordship said
I'll see that a short date is given. Make it next week, Rokhiyo. Because behind the back of the council, you can't do that. Next week, Rokhiyo. Yes, 64.
In item 64, my lord, your lordship was pleased to issue notice on the limitation matter by order dated 14 to 25.
Yes. Service complete?
Yes, no, service is complete. Yes. There is about delay of about 600 days, my lord.
600 days.
Yes.
Nobody entered appearance?
No, there is no appearance. But
Despite service, nobody had entered appearance for opposite party number 1 and 2. In the interest of justice, one more opportunity granted. Release the matter. One more opportunity, let us see. Release the matter. Nobody has entered appearance. Okay. It's made clear that in the next date appearing, if nobody enters appearance, the matter will be heard on its own merit. I'll cut on the delay next time if it doesn't.
Yes.
Yes.
65.
The existing in the manner. One dog was detected in a forest area from the manner. And it was loaded with kindles. The forester found the dog and the ready and starting for road. Runs away, dog on this forest. Now, two cases have been registered. The same occurrence. One.
Use the mic, sir. Mic.
But two cases has been registered for one occurrence manner. Because from the seizure of case started from the seizure of the truck. Leaving behind the truck, a person was running. Now, the forest case has been begun. The other case was stopped, stalled there in the SDM court. In the forest case, notice was issued to the petitioner. He appeared in the court. He was transferred to JMFC and it was concluded and judgment pronounced. He was acquitted. On the findings, this JMFC hold matter that.
Hold on.
My lordship, kindly have a glance to the flag K, my lordship. CRLMC 2908 of 2010.
Yes.
What would I?
For same allegation they have already.
No, there's not same
That was
allegation.
dismissed because of the, this is, even if the petitioner is acquitted under section 21 of the OTT rules, but the criminal conspiracy, my lordship, regarding he has taken, he was transferring the woods, my lordship, Kendu woods, my lordship. My lordship, they have, and one thing he has done.
What is this you are showing?
Let me,
My lordship, when they have filed before CRLMC, they come before this honorable court, my lordship.
Same party, because
yes, my lordship, and it was dismissed because the honorable court has observed in the last paragraph, my lordship, kindly have a glance.
At the time of framing of charge, it will
Yes,
be
my
charge is not in framer. Charge is not. Let me summon you kindly visualize matter.
No. See, what she says is, you have approached this court and this court has said that you raise all these points at the time of framing of charges.
The finding of the JMFC is that.
I am not on that. How will you get over this judgment of order of the coordinate bench?
In that case, I have challenged. There no two cases cannot be filed in one occurrence. That is my
again, you are saying the same thing. You have approached this court.
All right, madam.
For the same and there is an order. The order says, accordingly, it is ordered that if the petitioner so advised, raise the above contention, and the same shall be considered on its merit at the time of consideration of charge.
Yes.
No interference under section 482 CrPC is called for, hence it is dismissed. This is an order. How can you repeat your prayer? You avail the order, benefit of that order. That's the only way I can give it. What can I do? You have obtained. I have not done it.
I have
2019, you have taken this order. Right, for the self-same cause and prayer. The petitioner had earlier approached this court by filing CRLMC number 2908 of 2010. The coordinate bench of this court by order dated 25/6/2019 has disposed of the petition inter alia observing a general. Last paragraph, accordingly, it is ordered that if the petitioner so advise and raise all the above contention, the same shall be considered on its own merits at the time of consideration of charge. Full stop. No interference under section 482 CrPC is called for. CRLMC stands dismissed. The petitioner has repeated the prayer by filing the present CRLMC. Hence, I am not inclined to entertain this petition. However, it is open for the petitioner to derive the benefit of the order already passed by the coordinate bench on 25/6/2019. With this observation, petition is disposed. Yes, sir. Next.
66. Item number 62, 3 items are there. One sub item 2, CRLMC 201/2023. Notice have been issued, but due to late filing of petition, notice.
And second item.
And
due to non-filing of the refugees lately, the service on the opposite party number 2 could not be effective, and counsel for the petitioner seats 1 will tend to take fresh steps to serve opposite party number 2, lease the matter on such day along with the other people. Okay.
Other two matters, my lord, notices have not been issued, my lord. And already also the informant not.
You have not cured the defects.
I have cleared the defect, my lord.
Till first you say the parties are same?
No.
Parties are-
Informant are family members, my lord. 3 of the family members.
What are the offences here?
Your offenses are lord, under.
Okay, the remaining two matters.
290.
Remaining two matters simply issue notice. Huh? Okay. Please the matter. Yes.
Both the items.
Both the items. Yes.
Issue notice to the informant.
Yes.
Obligement.
May I please, Your Lordship?
Yes.
Prior to coming to this case, my lord, I have, Your Lordship, previously heard this matter.
Service.
Page 18
Service.
of my brief.
Service.
Item delivered.
Sufficient. Yes.
Page 18 of my brief. Towards class.
Anybody entered appearance? Nobody. Service ke behla. Yes.
Page 18 of my brief. How a malicious proceeding has been initiated in old person. It can be evident from the investigating agency's report.
Yes.
Page 18 towards last sentence. In this case, there is no item of evidence against the both the FR named accused persons, namely Basudev Pradhan and Gautam Pradhan. So and so, so and so. The complainant Rasmita Pradhan, her godly uncle Banamar Naik, godly aunt Srimati Bedi Naik, who are interested witness in this case, Jullu alias Ratikant Raut, have cogently lost this false case through the complaint. Rasmita Pradhan, for which they are liable on, would be prosecuted under section 211 of CrPC. After closure of this case, after opinion of the investigating agency, to initiate proceeding against the informant, along with others, instead of filing the protest petition, they have initiated a complaint case. Similar allegation, my lord.
Where is the complaint?
Complaint I have filed, my lord, before your lordship, my lord. Flag C.
Flag
C. Letter on that has been filed. Along with the statement of the witnesses. Complaint petition करा था, पढ़ा अच्छा लगा।
I have stayed the proceeding.
Your lordship, after hearing the parties, stay the proceeding and notice has been issued.
Despite service on opposite party number 2, none had entered appearance as yet. In the interest of justice, urgent to so and so. Interim order passed and yes, shall continue. Yes.
My lord.
Interim order to continue. Yes.
68.
Same person, they are the witness in this complaint petition.
I know because 211 I was recommended for 211 also.
11 to initiate against the complaint along with the witnesses. No. It will,
and in the complaint, he doesn't make any allegation against the IO.
IO, my lord.
Yes.
That is there.
I've seen it. Yes.
It will be short date, my lord. Because the old man, they were suffering.
Yes.
May I please, on behalf of Mr. Ashwanda Patnaik, my lord. In this case, my lord, last occasion on letter 3/1/2025, notice was issued.
Yes. Madam CD.
My lordship, CD has not received.
Okay. CD of the case as directed to be obtained by the State Council by the order dated 11/2/2025 has not yet been received. Urgent to so and so. Interim order to continue. Interim order
To continue.
Yes.
Okay, as well.
69 minor notice not happened.
Notice or my lord, open number 2 appeared, my lord. Your lordship kindly see the ground and the prayer, my lord. Here, my lord, stay order granted, my lord.
You are appearing for?
I am for the mother, my lord. The son, the elder son filed the case, my lord.
No.
And
you are opposite party?
Opposite party number 1, my lord. I have filed.
And who is appearing for?
On behalf of
Yes.
On behalf of PS dash personal difficulty.
My lord, your lordship, if my lord, you will take time, my lord, your lordship vacate the stay at least, my lord.
State interview.
Interim stay कौन? तुम्हें time ना वो mother is my lord seriously in my lord and your lordship kindly see the
One
photograph.
What is this? Let us understand what is this.
Yes, my lord.
Stay is granted for some reason.
My lord. Here, my lord, there is no ground, my lord. There is no ground, my lord. The main order had not been assailed before this honorable court, my lord. That is the 125 order, my lord. Now, my lord, DW issued under section 128 CrPC filed for execution. There, my lord, 72,000 passed by the London court. Against that, my lord, he has filed the case. And there is, your lordship kindly see the petition. There is no down.
See,
My lord.
you can get it from your husband.
Mother, my lord. Here, my lord, mother and son dispute, my lord. Dispute between mother, husband died, my lord. The elder, my lord, grab the entire property and stay in the house, my lord.
Umakant Ponda is
My lord.
another brother.
My lord. Another, my lord, he is a handicap,
What do
my
you
lord.
say?
The P number 2.
He is a beggar, my lord.
P number 2 is the physical handicap person. I will produce the certificate copy of physical handicap certificate.
Yes, madam. Why? See, the problem is you don't.
My lord, there is
You refuse to maintain your mother also.
On behalf of BS dash difficulty personal.
No, sir. In fact, my lord, he along with my lord, here, my lord.
Okay, I'll vacate the stay.
My lord.
Because see,
My lord.
I'll only for the reason that this is a maintenance order passed against you to give maintenance to your mother, and your brother is a handicapped person. How your mother will survive? She is 70 years. You will not even take care of your mother.
I have seen the difficulty in the eye of the mother, my lord. That's why I am testing, my lord. Otherwise, I will not, my lord.
Madam,
Not
there is
my
a
lord.
stiff
I will not. I have seen.
I understand your problem, but see, there is a stiff opposition. That's the whole difficulty.
My lord.
And after all, you are going to pay to your mother only.
Tomorrow.
If there is a single ground, my lord, I have.
Let it be tomorrow for limited purpose for vacating the stay. But she has some problem.
My lord, I have.
Yes.
Tomorrow.
Day after tomorrow. Day after.
My lord.
Day after. 70. And if you don't come, madam, I'll, if you are senior or you don't come, I'll simply adjourn the matter, vacating the stay. Okay.
In this case, my lord, I prefer this matter may be taken up after 2 weeks, my lord.
Adjourn.
The opposite, the petition number 1 is the husband, my lord. And
Okay,
he has,
simply adjourn.
yes, ma'am.
Yes.
71. My lord, 71 notice has already been issued, but some noting is there that notice has not been delivered. But I have given the correct address from the FAR and
And here also to implicate the informant as a party. Whether they
I'm
have
party notice.
Service on opposite party number 2 and 3 is incomplete. The petitioner to take first steps to serve opposite party number 2.
My lord, in this case, I have already filed an IA. Your lordship has not passed the order in IA. I pray, my lord, let till that date, my lord, this case may be stayed, my lord.
Stay is not routine, you know. Don't say, tell me, that's
My lord,
stay is not routine.
If I will file the
You've
time.
seen the stay, what is happening in
No, my lord, that
20, 30 hearing after taking stay, nobody comes.
my lord, in this case, what happened,
What
my lord?
do you have a case on many times?
Yes,
What
my
is this case about?
A case, my lord, that the victim in the same case, same year.
376.
Deposed.
And 6
My lord, I have annexed the entire, my lord,
whatever
copy of the
sir,
victim.
first you sir.
Victim.
Sorted. Yes.
My lord, if I will file an adjournment application, that it will be allowed.
Also is there, I don't know. You have not increased.
ସେ case ଟାରେ ଯାହା prosecution allegation ସେ ନିଜେ victim ଆଉ ତା ମା informant ସେମାନେ ମନା କରିଦେଇକି ଆଉ ଗୋଟେ story କହିକି ଅଲଗା କୋର୍ଟ ମାନେ acquittal ହେଇଗଲେ ଏବଂ ମୋ ନାଁରେ ବି ମଧ୍ୟ କହିଲେ ମୁଁ କିଛି କରିନି ମୁଁ ଆଜ୍ଞା ପଛରେ abscond
Then all of a reason I should not say. Now you will get acquitted. Why are you getting it stayed?
problem
What do you will get acquitted?
problem is ମୁଁ ସେଦିନ କହୁଥିଲି
You will be respectfully acquitted.
ନାଇଁ ମୁଁ ସେଦିନ
Don't stall the proceeding.
ନାଇଁ ମୁଁ ସେ problem ଟା ମୁଁ
Let
ସେଦିନ
it be that. Let it be that.
ଖାଲି ସେ application ଯଦି
Don't let the trial go on. You will be acquitted. Why are you creating problem for yourself?
ବର୍ତ୍ତମାନ ଆଜ୍ଞା ସେ informant ଆଉ ଇଏ ସିଏ ମୋ ପାଇଁ problem କରୁଛି
asking money.
ଆଜ୍ଞା ସେତେବେଳେ 20 ଲକ୍ଷ ଟଙ୍କା ନେଲେ ତାପରେ ଆଜ୍ଞା ଟୋଟାଲି ମନା କରିଦେଇକି ଗଲେ ଯେ ନା ଏମିତି କିଛି ଘଟଣା ହେଇନି ସାଇକେଲରେ ଆସିକି ଟିକେ ବାଡେଇ ଦେଲେ ତାପରେ ଆଜ୍ଞା ସେମାନେ ଖଲାସ ହେଇଗଲେ ସେ 2 ଜଣ ବଡ ଘର ପିଲା ଥିଲେ
Application
ଆଜ୍ଞା
72 मतलब this is an application for modification of the order मतलब GR case ଆଉ court name ଟା ଟିକେ change ହବ
GR case
para সেটা CTSS ହେଇଯାଇଛି ଯୋଉଟା GR case number 180A of 2023 ହବ
what have you written in your prayer just
ସେଥିରେ ଲେଖା ହେଇଥିଲା special ସେ city case
you have changed that
ସେଇଟା ହେଇଥିଲା ସେଟା କଣ ହେଇଛି କି ଅର୍ଡର ସିଟ ରେ ଯେହେତୁ ଅଛି ଆସିଷ୍ଟାଣ୍ଟ ସେସନ ଜଜ୍ ସେ ଗୋଟାକ
the problem is unless you change your petition how can I change my order my order is correct
I'll modify that I may be permitted to correct that
correct the petition first
petition
okay consequentially that will be changed
yes
okay
so
for the petitioner Mrs. Mishra and the counsel of the petitioner submits that there is an error in the case number in the order dated 10/3/2025 and the same has been is caused because of the inadvertent error that has cropped in the trial court proceeding and eventually in the prayer portion of the main petition. He seeks amendments to the prayer portion of the petition and accordingly seeks an modification in the order dated 10/3/2025. Regarding it to the reasons stated in the application and statement made by Mr. Mishra at the bar, the petitioner is allowed to carry out the amendments in the petition in NCRLMC 562 of 2025. In the event the petitioner carry out the amendment, the order dated 10/3/2025 shall also be modified accordingly. In case of CT bracket sessions case number 135 of 2023. What is the number?
GR case number 180A of 2023.
Shall be replaced.
And magistrate se jo GA ହେଇଛି additional session judge Kamakyanagara ସେଟା SDGM Kamakyanagara ହବ.
Whatever you give in writing.
In the prayer portion it is.
And you have not asked one thing, 30th March extension.
Extension.
You will not ask again, you will ask. Move another application. 20th April. For the reasons we could not surrender. 20th April. Okay.
Lordship, item number 73. Sir, appearing on behalf of Mr. Sir, appearing on behalf of Mr. Mahanti. Can the matter be posted to another day?
Okay, adjourn. Yes.
74.
Informant of the notice. 490 matter of lordship is to notice to the informant or
This is not found. Address is not found.
Is there? And you lordship may kind of glance to page 14 of the
Address is not found. What will I glance? You satisfy?
This address, that is the address she has mentioned in the fact.
Or through ये करो share link ना through IIC serve through IIC opposite party. Yes, for the notice was sent to the opposite party number 2, which has been returned, answered with a postal remark. Address is not found. Address is not found. Then the counsel for the petitioner says that the address which has been given in the petition is the correct address. Hence, the service of opposite party, service on opposite party number 2 is purchased IIC song. Next.
75.
Item 75 modification of order my lord. एतरे ST केस जगह स्पेशल केस टी होबो.
ST case special case.
आज्ञा ST जगह स्पेशल केस होबो. आ नंबर सब ठीक अछि.
अरे just see the prayer you what have you written? Prayer you have written ST case. Petition you have written ST case. Everywhere you have written ST case.
My lord.
Everywhere in your petition you have written ST case.
My lord ST case. My lord wrong number ଦେଇଥିଲେ, Lord trial court wrong number ଦେଇଥିଲେ ST case. ତାପରେ ମୁଁ ଆଉ ଗୋଟେ ଦେଇଛି ଆନେକ୍ସ କରିଛି ସେଟା ଯୋଉ ସ୍ପେଶାଲ କେସ୍ ହେଇଛି ରଙ୍ଗ ନମ୍ବର ପାଇଁ ଆମେ ଆଉ ସରେଣ୍ଡର କରିପାରିଲୁନି ଆଜ୍ଞା।
For the same order. Petition first amendable, consequently it will be more. Yes.
Further extension of time, my lord.
For the 20, yes.
Oblige, my lord.
Out notice. Yes. Who type? 96. 96.
96. I beg pardon. In 96, both they have got married, both husband and wife, they have appeared before your lordship.
Yes.
In this case, I have filed a CMP challenging the annexure 5, your lordship.
5?
Yes, my lord. That is phase 27 to 31, your lordship. The rejection of petition under section 10 of the CPC for stay of previous suit, that is suit for partition. I am the defendant to petitioner before your lordship. That petitioner filed a probate case which is pending before the district of my lord.
2019, this was rejected. What is the position today?
My lord?
What is the position of this?
My lord, the interim stay is there.
Interim stay passed here in this. Oh, sorry, is there?
My lord. No, issue notice, the other side is appeared today.
You are appearing, sir?
Yes.
Yes. Yes, tell me.
My lord, in this case, probate case is already dismissed. I have filed a IA 1352/2024 along with the entire order sheet, my lord. Since 2022, 9/3/22, no step taken by the petitioner. The petitioner is absent on repeated call. Defect not removed. The test
Yes.
has not.
What do you say now? There is nothing, sir. Why?
The order is there.
Then, on the pretext of that only you ask for moved application under section 10. That is dismissed, then gone.
Yes.
I'll dispose it up.
Yes.
Right up. Petitioner is agreed by the order dated 22/2019. Passed by which court is this? Passed by Civil Judge Senior Division, Banapur in CS number 35 of 15, whereby the application moved by the petitioner under section 10 of CPC has been turned down. Turned down. The petitioner the Prime Court turned down the application of the petitioner. How to bring in. Need to. Sorry, there. Okay, no, I find it's that's
This is case where a private loss against unknown persons in 1995 and 64, after subsequently 96 charge sheet violation. As far as these two petitions are concerned, we are two brothers. They have been implicated on the basis of What you stated.
Shared opposite from the two. You see?
हाँ अपन लास्ट पेज में मुझे पढ़ने बता एफिडेविट फाइल करे विद द स्टोलन ट्रक that was
इतने करने में तो ऐसे ही है. This was not possible. Since one is like time to take major steps, so with part number two.
Why see where from the
Anything order pass the years and continue to make it. Yes. Take steps.
how did
Yes. Something or we can. 84. Yes.
But instantly the petitioner are challenging the illegal order of taking cognizance under section 8C, 20B, 2C, 28 and 29 of the MCS Act. And also that the basis of the blood implication of the patent petitioner potential confessional statement of the report. So also all well settled by the one thing I am relying to just have a note last occasion. Given a note. The narcotics the NCB team have collected rate and what has now happened is not the application for release of what is but I will also make a response. Because the report has about it, I think it will be this petitioner has killed the let us see what is your report in that. What report you filed in the habits of the school? All this okay. So it is for about the petitioner submits that the habeas corpus petition being W2 criminal number 109/2021. Who is good afternoon? Informant. Including emergency signal, opposite party number 4. On the basis of a report by the investigating officer, the minister of system has been closed. Let the person matter be listed along with the record of road, petition number 109 of 2021. And after 2 weeks, we want to contact. Yes. Yes. There is compromise today in a matter case from 19 of 24. Today. The directed both of them to appear on 12th May. 12th May. In the case of 494. Here also, then I'll read it after 12th May. 12th May itself, then find affidavit here. Okay, read 12th May. For personal appeals or ultimate direct. 12th May. Imprimor to
in the Martha case being number 19 of 24. The parties have and directed to appeal and decided to move the mutual divorce application. Decided to move application under section 13B on 5th of sorry 12th of May. Therefore, it is that day, and so that both the parties yes. Yes. What part of this side? That's the level of the coming to that. That's the level of the problem. 22. Cases such as which are going for government arising out of power, there are two profiles. One is 18 years, that for 3 years, and the other is 17 years. Once there are 3 attacks. After 5 years, one attack, the doctor can police that I have gone with that boy. The case was closed when Mr. Doctor. Against that, after 5 years case, that everything the first prison. Everything out of additional sessions of the Cognizance of 376. The government was married the boy. They are deciding one child has been born. Where are they? Where is the Malaysia? Where is the Malaysia? I have missed yes, that was not been mistake. I don't know that something that fasting should be good. No. Very difficult, but my God, this is only when I learned that currently fasting or secondly on PP. Yes. My Lord, one thing is that the father, number 2. Pilot says the direction of pilot I have issued the notice. He is not coming. The pilot previous I say also then would issue notice opposite party number 2. Service or opposite party number 3. Are you of the case directed for opposite party number 3 or matter after Muslim purpose I'll say again. Muslim purpose as per when you want. We don't have to rules. Smiler. I appreciation, but discharge having been rejected, I have come up. Smiler. Yes, sir. In this case, a disproportionate case has been instituted against the person and his wife. And while I think chances they have included the assets of the children. Those were prosecuting their study in the Bulla Medical College. Oh, that was the case. Yes. Yeah. Right. Thereafter also see these cash is being deposited. Yes, I'm explaining it. They have received son and daughter, they have received 16,000, 16 lakhs, 90,000 and 12 lakhs, 74,000. From out of that, they have filed documents to show that some amount has been deposited by the mother. The total amount is 75,000 and 90,000. From out of about 30 lakhs, only 93,000 plus 71,000 these are being deposited by the mother. Can it be said that it is operated by the mother? Some amount has been sporadic to deposit by her. That doesn't mean that the entire amount has been deposited by mother. Yes. More. Sporadic deposit of few occasions they have deposited. Few occasions, 2,000 rupees. Yes. These deposits are being confirmed by the prosecution By examining the accounts officer of the Birla Medical College. They have taken this amount has been taken to the account of the students, madam.
Actually, I know about this, madam. And they got stuck because the students, they were the student and the money used to be deposited in their account and all. Yes. So that's the reason I was not inclined. Let us see what he says. What are the material against this?
I think it's concerned. Placing the statement. We have made deposit in SBRA accounts also. The opponent. 51 branch in the name of my son Samarandan Patni Pradhan. It is a fact that SBI accounts also open in the name of our son Samarandan Pradhan and my wife have made deposits. All transactions are made by us. So all also in the SBI account was in the name of a Satarina Palestine. Is it fact that in the year 2013-14, my son had no earnings. My wife had made deposits by herself or by sending some other in their bank accounts from the business and money. So this is the statement of the petition. And another aspect is not a single money has been transferred from the account of the petitioner to the sons or daughters. And coincidentally, the money has been deposited the accounts by way of cash at the petition number 2 or by some other person as per their statement sending them. And at that point of time, the petitioner, the son of the petitioner, was forcing NDA study and was not getting no stipend. And so far as the doctor is concerned, at that time she was married. And she was residing at UP. Money has been deposited in the accounts of the by way of cash by the mother and other persons.
Hey, how many occasions and what you do? Stand up.
No. You have filed the document.
Thank you, thank you. Your statement is gave me many things.
It's a case arises out of a type of inquiry. And during investigation, petitioners in that so much they have written given in writing to the investigating agency, don't include my children. They have not given a single fight to us. Well, ultimately, I need to see the document they have to. And at these things, and now the submission so far as that the wife, the sons, daughters of assets have been included. That is not correct. Only deposits which have been made by the petitioner or by the petitioners in the accounts of the only 2 accounts have been in the fixed deposit accounts, and all has been deposits has been made incidentally in the same day when the doctor was residing at a BP with her marital house, and not a single pay has been transferred. That is that statement, and the daughter and the son has also given such like that. They have not given a single pay. We have created that statement. Well, also time to we have kind of time to see the documents. 15/4/2014, that has been deposited by the mother. Here. 9/6/2014, 22/7/2014. Only 3 deposits have been made by the mother. In especially the account of SR program. In respect of the account of program, there are 3 deposits. 10/4, 96 and 52/7. These are the only documents show that the mother has deposited some amount in the account of the children, madam. All other amounts have been deposited by the Birla Medical College itself. They also kind of the 156. Sorry, 9. The accounts of the Birla Medical College. Nine. That is their document.
What did you change now?
That dissertation has been written by us. I have come up with this one.
Into this amount deposited in the account, was not deposited in amount of the son and daughter is taken off the record, what will be the percentage?
Very low. It will be reduced to less than 10%.
That is not the biggest time just asking for.
Doctor is married, only for the purpose of make out the case, they have included this amount. Yes, the found that the asset stands in the name.
How much, what is the stipend amount you have got?
Yes.
16 lakh and
16 lakhs 90,000, 921 in respect of Dr. S.R. Pradhan, and 12 lakh 75,480 in respect of Satyena Pradhan. So that forms the
you take up the entire amount and give it directly.
because I have received from the government, not that from private area. So that is why I am bringing over also. Statement of
How, let us see the, how the, charge sheet deals with that.
let me submit.
Yes, I got it at this.
No, but only one thing I will bring it to worship office. It's statement of concepts. Finally, 69, page 69. Yes, really. Dr. Satyena Pradhan, then his admission in his 3 year
Nothing in jail.
3 year PT course. She has been paid total stipend amount of 12,75,480. That is the amount credited by the government.
Check period?
Check period is 86 to 51, 12. Amounts have been deposited during the course of the prosecution. What is the prosecuting the study? Yes, so similarly, you will also make all this Sundaranjan Pradhan. He has received 16 lakhs 90,921. Medical college. This is in respect of the accounts matter. Now you are also trying to see how modified they are. Acting in modified. In the charge sheet itself, I am relying upon the figures, fact figure mentioned by the prosecution in the charge sheet. Why they have included the wife when her income exceeds the assets produced by her? Charge sheet, you also may kindly see charge sheet.
No, come to page 63. 63 entry number,
My lord.
27 and 28.
My lord.
These are the amount of pertaining to Catalina and from your taken into account. 1,99,000, the thing 26,000.
They have taken instead of the amount which has been credited to the account.
Let us see what amount is taken into consideration. Factored into your
Only this amount to calculate I will calculate. So far as the doctor is concerned, he will date of marriage. Her marriage was a long marriage. 2011 she got married. Thereafter she pursued the PG course at her in-laws house. So her expenditure, her assets, everything has been ignored because we do not want to bring into this case, include now the petitioner funds, they should be included. Then there should be open inquiry. No, I don't want they should be included. I will file petition for de-investigation. Let them be included. In included for I agree at least it's
you simply answer me one question. Whether the stipend amount which is received by the daughter and son is factored into the disproportionate asset or not? Simple answer. You give me.
No, so far as stipend amount for doctor is concerned,
Yes.
we have not doctor and son is concerned. Their assets, their expenditure, everything has been included. Income नहीं नो, the asset का expenditure भी नहीं ना. Reason is that so far as stipend during PG course is concerned, they are getting the stipend for the purpose of prosecuting the
Not factored. It was not factored.
not factor.
Then
Kindness of false statement.
not factored, then what?
No, kindly see it. Page 59.
59 in there, in there to there.
59.
And there.
Item number 4. Then we show that Pradhan 7,74,132. That has been included in the assets.
7 lakh 70. Because it is disturb submission, then it's not pursuing the case. Yes. And item number 5. That is the account of settling of the 8,31,000. These are the assets have been included. That's right. What is the case is, it is not the amount you got from the what you call the stipend. These are the amount being deposited by your parents in your account. No. That is the they have filed document that I can't do it. And this says, do you I asked a very specific question. Whether the stipend amount received by the corporate factor into the disproportionate asset or not. The answer is no. And had it been, I can understand, had it been 12 lakh, 16 lakh, this is why you file. So we figure 12 lakh, 16 lakh, factored into your list of. No. Clear to your thing. But I am very clear. During the course of doing the check period, these two persons have received 16 lakh 9,000. All these things are taken into consideration. Once again, these receipts, if amount stands in the name of the bank account, it's 8,31,000, 7 lakhs for that. That is within their resources. Whatever, but I can't do in accounting business now. Because there are statements, one statement where you have said, both the accused have said, we have been depositing in the account of our statement has been created by the. What to do that? At this stage, I have to rely upon the one. I know, but what to do? I can't ignore that unless this that is there in the statute. What can I do? At the charge stage, I have to look into that. I have to, draw corroboration from that. That is what is the document available by. That is why my submission is there. Then I have to be a chartered accountant now. No, accounting. There is no question of accounting. No, I don't think so. That's all. And we have said, next submission, we have spent equal amount of time last time. No. I stopped here only and necessarily I have to pursue the matter. No answer to that. Allow me to do that. As a next submission, the wife has been implicated in the case. Kindly come to the charge sheet. I'm not finding anything from my wife is Jyotirani. Yes. Just see the assets, trying to gather what she is doing. Business. Then again, you can't get the benefit of the judgment of money. You are doing business, the bonus is on you to prove. Yes, I will have on charge sheet matter. I'm not finding any document from the home. I will have on whatever they have collected during the course of investigation mentioned in the charge sheet. You are also trying to come to the answers stands in her name. It's serial number 26. Yes, 26268818283. Yes. And serial number 2 and 3. That comes to 37,87,000. As per the charge sheet. Yes. I think that the version of I will on to page 63. Last item 30. Total business income is 50,91,000. She had earned 50 91,000. As against that, this asset stands on in her name comes to 37,87,000. Why should we prosecuted? If assets acquired by her is within the legal means, why should we prosecute? So whether that is taken into consideration or not? Yes, that is something. Computing all these things, they have come to the finding. Where is your audited account?
audited account of food. Now, that is arbitrary. See, why you have 50 lakh, and your account might be audited. Where is that?
No, they have accepted, the prosecution has accepted it.
How can I go into?
That is mentioned in the charge sheet.
Come to page 59. 8.
9.
8. 8.
Yes,
The deposit.
yes, my lord.
Let's see the deposit. Here the deposit is in between sub clause 4.
Yes.
Soumyaranjan,
Yes, that has been mentioned.
again, Soumyaranjan, you have to be again settling this much, and the balance is this much, and all these things are taken into consideration.
These documents disclose that we go to projects, madam.
Very difficult to go into all this.
No, I'm not, now, my commission, the assets and the income of the wife. The charge sheet discloses, they have taken charge sheet amount, the income amount mentioned with the charge sheet, 50 lakhs 91,000, that is the serial number 30, is 63.
63.
Yes. Yes. On the basis of the income tax returns, they have computed it, 50 lakhs 91,000. Other than that, the lady acquires the assets, possesses the assets,
52, where is it 57?
57?
No,
50 lakhs.
50 lakh.
50 lakhs.
Total business income found as per the document.
57, no, sir, 50 lakhs 91,000.
This is the Lakshan Kumar Pradhan.
No. It is the,
From the dairy business, future business, so. This is the original account. 50 lakh. Yes,
50 lakhs. Other than the income, the asset stands on them, on that serial number I have already mentioned.
What it comes to how much?
37 lakhs 87,000.
Yes, Mr.
Expenditure for watching it, the Pradhan produced for the document. And sees technically that income tax asset. You have filed this asset. In spite of my income, it's more than the asset starting.
What is saying in your own charge sheet? Entry says 30. You say her income is 50 lakhs 91,100. And if she holds the asset of 37 lakhs, you have factored that into the
37 lakhs, 73 lakhs, it is request to be calculated. The expenditure on the face of it. Face of the record, they are showing only 2 assets.
Assets, whatever you mentioned, you will answer. That income is 50 lakhs, and the asset acquired by the wife is 37 lakhs. It's a total asset. However, we factor that into the disproportionate of the husband.
My lord, if there is 50 lakhs for the consultancy, that document has been produced by the petitioner one. You have accepted in the charge.
You have accepted it. Your investigating officer has accepted it. The income to be 50.
There's 63 lakhs.
Okay.
Item 30. Total business income found as per document produced
by him.
By the accused document Pradhan. By the wife.
Yes.
From dairy business, stitching business, decorator business. So the business, as far as the business is concerned, he was going by the.
No, if you read there, Bharachor, as well as the original acknowledgement copy of IT return. IT return from 10/10/20. And this is derived from IT return.
Returns of whom? That is to be examined.
Take it up and tell me whether it is IT return for the IT return of the wife, or it is IT return for the husband.
Categorically, the wife by income tax asset from Adhika, we are going to have space.
That is what is the thing. You just check it up and tell me whether this IT return which is reflecting in 30 is the IT return for the Lakshman or Jyotsna. These are the things you have to examine. If it is Lakshman, then he doesn't have a case. If it is Jyotsna, then we have to look into it.
Yes,
if income exceeds, then we take it up. If he can get the benefit, why not?
And That deposit is concerned, that deposit is closed. You will not argue next time. Only this. Deposit is closed. That I am not here. Don't repeat it, please. This, there is you have a point.
My submission is the law firm cannot do business because he is a public servant.
I don't know who is produced and who the ID written. Nothing is reflected. Not produced.
What will you apply? Because
I'll tell you why. How will I know from you? I have initiated that I have let him come out with this because ID written are not placed on the court. They are in possession of those products. We let him verify. Yes. That's it. Part, you know.
And with the lordship. The lordship may kindly see the last order, passed by your lordship. Order dated 21/2025. Mediation, the lordship was pleased to send it to mediation.
What happened?
Mediation, okay, because the open number stated that they won't write in the mediation. And the present petitioners are in-law. It's not only number one mother-in-law. Second-in-law, sister-in-law working in a job at Bangalore. Third is marriage sister-in-law, fourth is the brother-in-law. He is a police official. There are some kindly 490 cases and others, an extra 2 to 5. Neither the petitioners have been named in the FIR nor charge sheeted.
Fifth recording. This 12 we want to continue. Yes.
But kindly say,
Fifth, I am keeping it for this 12 because that is a Saturday. Entry motive. Yes. Because he doesn't come, he will not come out. Will be
Then appearing for number 2.
What is the use? I have sent it to mediation, you are not cooperating there. Last time I recorded that you will cooperate, still you are not doing it. Unpass it, and face it. That is their attitude. Yes. Next.
And for 94, my lord, I'm praying for an adjournment.
Very quickly.
95.
95 will also be praying for an adjournment.
basically 1.5 days, 4 years have passed. They have 30,000. Thereafter, my word, because of the claim order, he is not taking care of that.
I have only paid the and yet to pay
30,000. Thereafter, he has not
Nothing. And he's out of town to attend some family business.
You have to pay maintenance.
It is 2,30,000. He has paid 30,000.
So it may fall up to free.
I'm not paying. Why don't you? I can't,
That is the settlement. They will pay that continuously 5,000 only per month. 3,000 is for mother, 2,000 for that. He is not for 4 years.
We have a council for the business. One agreement is sought, which is given a full flight in the council for the opposite party. In the interest of justice, last chance of the business to repeat and argue the matter. Needs the matter.
Interim order. Interim order.
That is, the interim order is the creating problem. And then no interim order, you would have come and argued. In a maintenance petition, take an interim order thereafter.
Subject to deposit of someone.
Yeah, I can't, you can't convert it, pour it into code to an execution code. It is an execution code.
I don't have it for payment of 30,000.
Right, but I can't, pass the order without hearing the other side to pay this much, pay that much. See, ultimately, it's arising of an execution proceeding. NBW was issued, I said, subject to he paying 30,000 rupees. For the bona fide. Who paid it, whether it's going there or not, I don't know. It means it's there, but I have not paid any proceeding.
NBW has been said that for lower court.
NBW state means only he will not be arrested. He has to go and participate. Participating, obviously.
No, but okay.
Then we insist for NBW. That's NBW. Either in this. NBW is for a particular day. I said that. Subject to he appearing on that day. He appeared. 30,000 rupees also. So suppose you have to insist there. Why this matter is pending, by the way? Challenging the entire this thing. Okay, I will see.
He is telling the main order.
Can't, that is the order because of the compromise. I is ready for that. That
We'll consolidate to do. Take.
that is seven.
We accept that.
Sure. You can go.
And eight. Application for challenging the order of cognizance which is taken under section 138 of the Negotiable Instrument Act, my lord. The lordship, the humble prayer before your lordship, it may be referred to the mediation center for mediation. If you fail the mediation, then your lordship will kindly consider the wrong verdict. That is check bounce case, my lord.
What is the stage of
That is, as per your lordship.
Taking evidence, my lord.
Please go in.
Now the matter is.
Then I will dispose it up and go and
My lord, later the send the mediation center.
I'll send it. I'll ask the trial court to send it to mediation and
No, man, try to mediation center.
right now.
Now your lordship to send the mediation center because you hear
Direct direct for mediation center. Contact mediation center.
no, my lord,
Any matter pending.
but
District mediation center.
mediation lordship direct because the mediation center are there, it is possible to the parties.
But why it is pending here? Cognizance order, why should the court has not entered, not going to enter?
There are no stay of the operation of
That's what I'm saying. Why? What is the matter? Let us see the cognizance order. What is wrong in it?
That's 138B notice, demand notice has been sent by the complainant in the name of the petitioner. That has not been solved.
Let us see the complaint, copy of complaint. Where is the copy of complaint?
They have filed their objection, but they have not filed the copy of the envelope. And whether that is service or that has not been service, only they are stated in their complaint, refuse to accept. The petitioner has been staying since 2021 in Bhubaneswar, Manila, and she is the employee. She has not stated the amount of 13 lakhs in check, Manila. That was written by the complainant. And such an amount has not been taken by the petitioner, Manila.
Where is the endorsement? You have the endorsement.
No, the endorsement that has not been filed. Because they have filed objection, but in the objection they have not filed envelope of endorsement and the envelope of the.
No. Just see, come to page 16. Page 16, come to page 16. The documents are filed. It is a debatable thing, but now you have to go and prove your case.
The matter is now ready for hearing.
Let's see what is filed, original check, file, bank endorsement, insufficient fund, this is filed. Previous legal notice, 31/5/2022, which was sent to you. File. Return, just see, return postal envelope containing demand notice, it is filed.
That is my contention before this, your lordship.
Yes.
Because that notice was just done under section 130 by the advocate. Before filing of the case, that notice is not sufficient. That notice is written back. But it is on an edition.
What was the address given that note? Show me the notice.
Address in the address of
the notice. Copy of notice. And show me your address here in the complaint.
and notice, I have not received the notice, how I am honest that notice.
Part of the document has already been filed in the debate.
That is filed in complaint, but they are filed.
You have participated.
Yes, madam.
So you might have got the entire copy. Don't say that you have not got the copy.
No, I have not got the copy. I have got the order of cognizance as well as the order of the copy of the petition.
No. The other thing also you are for petitioner or opposite party?
I am for the petitioner.
But then you are the accused, you might have got it.
Madam, for time and giving, I will collect that.
Why this case is pending, I don't know. There is nothing in this case. You have to go and contest it. In 138 matters, unless I'll send it to mediation and dispose them. I don't know. If there is no case, petition is agreed by the order dated 19/8/2022, passed by the related is detailed in ICC number 127 of 2022, by millions of proposals under section 138A9, initiated by opposite party against the petitioner of the meeting. The only contention of the petitioner in the petition is that the category meetings under section 138 to bracket B of IP also the NI Act. Also was created to be sent to the petitioner, but immediately change was not showed on him. So, therefore, the complaint subsequently filed against the petitioner is not maintainable under section 138. I have gone through the contingent rates. I have gone through the evidence made by the opposite party in the complaint in para 8B, 8B, difficult 8B, 8B and 8B, the opposite party in the complaint was also includes the documents, all the documents, including the inverted comma, postal envelope containing the demand notice which has been written. In the fact summary of the present case, since the notice was sent to the petitioner which returned because of the refusal of the petitioner to accept the claim, it almost lying on the petitioner to discharge the the petitioner will be looking to discharge the notice that is non receipt of notice. The matter was taken up for hearing on 15/8/2024. Notice was issued to the opposite party. Now appears for the opposite party. In the order it is 15th of May, shown to appears from the opposite party, Mr. Vinay Kumar Mahant. On the order dated 14/8/2024, as also indicated that the trial of the case go on. However, no final decisions will be taken. The counsel sitting for the parties convention permits that the trial is proceeding at its own pace. Regarding head to the aforementioned, I'm of the considered review that the trial court should proceed with the case. However, before further proceeding in the matter, the trial court should explore the possibility of settlement between the parties by referring the matter to the district mediation center. With this I'm not inclined to entertain this petition at the stage of cognizance. However, subject to the observations made above, the petition is disposed of. Yes, next.
Thank you, guys.
May please, madam.
Yes.
In the proceeding, criminal proceeding in 160 number 216 of 2023, under section 130.
Who is appearing for opposite party? Yes, Mr. Ponda, you are appearing. Yes.
There are two orders. I'm giving. Main point is 200 sufficient follow.
200?
200 sufficient. Before issuing summons, the complaint has to be examined. Married in CRLMC 205824 para 6. Married has quashed the cognizance order, limited back to the complaint para 6 married. CRLMC 205824 order dated 20th February 25. Section 142 enact mandates that the present nature within a period of keeping and they limit back the matter to grantor and affording opportunity to record the testimony.
Several cases has been filed by the present petitioner, present opposite party, and out of the 2 cases, your lordship filed this order.
The same order will pass.
Both of you are saying same thing.
No, no, I am not saying same thing, but because your lordship has passed an order, so.
Then he is relying, you are also relying upon this.
Yes, yes, because your lordship has remitted the matter.
Then
Your lordship has
that's what I'm saying. You are conceding it.
Yes.
Right now.
Another case is my lord, that is CLMC 2138 of the.
Where is it listed here today?
No, disposed of.
No.
I have given that
This is two
judgment.
matter, na? In this line. Yes.
But I mean, pardon, my lord.
Yes.
In CRLMC 2058-24, my lord has directed to prevail within a period of 3 months. That because
We'll
I
see.
another case 6 months. In this case, up to 3 months.
Yes, we'll see.
My lord. Okay.
Alright. Same online test.
2058-24.
Yes. This was, yes.
100.
What pass over at the midnight? Midnight pass over. Yes.
345 at 345.
Simply, how it record years out. Least how will see. Yes.
101.
Unless 2 page 30, the cognizance order is under challenger lordship. This offense under section 294, 506, 34 IPT.
Yes.
The case and
Immediately
count
for
of
opposite party number 2.
last occasion, someone asked your lordship
Anybody
and
appeal?
your lordship. And on that day, lordship, she stated that he has no objection if the FRL quash, the proceeding will quash. And though case and counter case is there, your lordship suggested
Other case
them
also
to
to
file one. No, they're not responding. The requirement.
The stay is operating. Let it forward.
Lordship,
Non-APS for
my
opposite party
predicament
number
is
2.
that, lordship, the present petitioner is met a severe accident and a bedridden. His son trying to
What
shift
to do?
his
The opposite party number 2 is not there behind his back. I can't do it. I have to
no,
hear him
lordship,
also.
lordship, on that purpose, the lordship.
I know, but
Yes.
you bring him. I'll hold it. Bring him.
ନା ସେ ଲାଷ୍ଟ ଡେଟ୍ ଆସ ସେ ଫାଷ୍ଟ ଆସିଲେନି ନୋଟିସ ପାଇକି ଆସିଲେନି ତାପରେ ହଜୁର କହିଲା ପରେ ଇଏ ଗାଁରେ ତାକୁ ଇନସିଷ୍ଟ କରିକି ଆଣିଲା କାରଣ ଆର ଦେହ ଖରାପ ୟାର ପୁଅ ଚାହୁଁଛି ଆକୁ ସିଫ୍ଟ କରିବ ପାସପୋର୍ଟ ଯେତେବେଳେ ଆପ୍ଲାଏ କଲା ଜାଣିଲା ଯେ ଏମିତି ଗୋଟେ କେସ୍ ଅଛି ଆଲିଗେସନ ଲର୍ସିପ ଫର ଏ ମୋମେଣ୍ଟ କାଇଣ୍ଡଲି ହାଭ୍ ଏ ଗ୍ଲାନ୍ସ କିଛି ଆଲିଗେସନ ନା ମୁଁ ଫୋନରେ
That is the reason I say asked him to file the another
କରୁନାହାନ୍ତି ସେ କରୁନାହାନ୍ତି କିନ୍ତୁ ଅନନେସେସରି ଡ୍ୟୁସ୍ ପେଣ୍ଡେନ୍ସି ଅଫ ଦ୍ୟାଟ କେସ୍ ଲର୍ସିପ ମୋର ପାସପୋର୍ଟଟା ମିଳିପାରୁନି ମୁଁ ଆନେସ୍ କରିଛି ପାସପୋର୍ଟ ଆପ୍ଲାଏ କଲା ପରେ ଜାଣିଲି ଯେ ମୋ ନାଁରେ କେସ୍ ହେଇଛି ପୋଲିସ କହୁଛନ୍ତି ଚାଷୀରେ ଫଟୁଆନେ କମ୍ପ୍ଲାଏ ହେଇଛି କିନ୍ତୁ ମତେ କେବେ ଡାକି ନାହାନ୍ତି କି ଫଟୁଆନେ ମୁଁ ସିଗ୍ନେଚର କରିନି ନୋଟିସରେ କିଛି ଆଜ୍ଞା ସେମିତି ନାହିଁ ଆଉ ଏଫଆଇଆର ଆଲିଗେସନ ବି ଦେଖିବା ଯେ ମୁଁ ଏଠି ରହିକି ଫୋନରେ ତାଙ୍କୁ ଧମକେଇଲି ବୋଲି ଦ୍ୟାଟ ଇଜ ଦ ଆଲିଗେସନ ଆଉ 204 506
I'm with you, but what can I do? Once I issue notice, I have to hear him. I'll bring him, call him, bring him.
Last occasion she ରହି କହିଲେ ଯେ they have no objection if the proceeding will be quashed and ସିଏ ଆସିଲେ ତା କୋର୍ଟ ୱେଟ୍ କରିବେ ତାଙ୍କୁ
Have you recorded his statement? Show me now. I'll see that.
ନାଇଁ ହଜୁରଙ୍କ ପାଖରେ ହିଁ ସେ କହିଥିଲେ ସେ ଯାହା ବି ହଉ
How do I remember all these things?
appear କଲା ପରେ ସେମାନେ ଯଦି ଆସିବେନି intentionally to harass the ମାନେ I am a bedridden person medical document I have annexed
Short date दियो entry mode continue short date first week कर दियो
note ହଉ ଆଜ୍ଞା ତାଙ୍କର non appearance କଥାଟା
despite notice the opposite party number 2 although have entered appearance through which counsel through Mr. Cognizance the opposite none appears for the opposite party and consequently the petitioner submits that the opposite party is employing these ploys only to harass the petitioner by way of last opportunity these matter on circumstances for hearing entry mode to continue commit of the third fourth seventh it is made clear that no circumstances the present matter will be adjourned. Yes.
102.
Application.
Kindly have a glance to the report of the mediation center, madam.
Yes, mediation successful.
No,
Huh?
they did not appear, my lord.
Hey,
Mediation failed because of non-cooperation of the opposite party number 2. First date, when notice was issued, notice returned also. On the next day, he submitted that he is deliberately avoiding proceeding, so the proceeding may be dropped.
My lord, kindly have a report dated 22/2/2025, my lord.
why have you not cooperated with the mediation process?
Yes, my lord, we have cooperated, but they did not appear, my lord. Kindly have a glance to the 22/2/2025. They personally received the date and the posting of the mediation. Thereafter also they did not appear. On dated 2025. Willfully did not appear.
I think the records are with
But you remain absent.
Yes, my lord.
You remain absent.
No, I remain absent. My client remained absent. I was present.
No, just see the report.
I was
Today the petitioner is absent, but the counsel for the petitioner is present in filing the memo of the same time to ground or illness of the petitioner. Opposite party
I filed a memo.
is present along with his counsel. Opposite party has been appearing. Opposite party in the memo through the counsel
I filed a
stating the
memo
illness of the
stating
petitioner
there
is
is that I
voluntarily
am
failed
ill.
to appear in
But the
mediation.
petitioner is ill.
So and so. And today that is on the to avoid so petitioner so and so. And it is because of your non-cooperation things are happening.
One date, my lord. Notice was sent.
Why are you giving a picture as if opposite party number 2 has not appeared? You didn't appear.
My lord,
That's the report. What to do?
I was present. As a lawyer, I
Then
was
what?
present.
Then what I'll do? What I'll do is I'll call the mediator. I'll cross-examine him here. Who has appeared? Who is not appeared?
I filed
The report is that you have not
I-
appeared.
My lord, I filed one memo stating therein that
I don't know.
the petitioner
You
is ill.
you are interested to settle. You settle. Otherwise, don't settle. You have obtained a stay order. I have sent it to mediation center. You don't go there. And mediator says that you have not appeared. What is this?
The petitioner was ill, my lord. I filed one memo.
Then why have you said that he is not appearing? Opposite party.
They are not cooperating. I am not saying that
What is it? You don't appear, they are not cooperating.
They are not cooperating.
Very funny.
Very first day, my lord, when notice was issued, notice was not served.
What was the, let us see, what is the matter is about?
Notice was returned unserved.
See, what is the matter is about? It is
Matter relating to 138 NI.
you are the accused.
My lord.
Why should I interfere? You tell me now.
Matter is likely to be settled.
No, likely. You didn't.
Very
You have taken the court's order granted. Nothing doing. I have given an indulgence to you. At least give an opportunity to go and settle.
My lord.
You took a stay. And there you move application and says that he is not cooperating.
He was ill, my lord. I filed memo.
Deposit 20%.
My lord, my senior will come, my lord. Mr. Student.
Deposit 20%. Then I'll vacate the stay.
My lord, the passover, he is on his legs before court number 2. He is coming.
This is unfair.
One passover.
In a 138 matter,
one passover, my lord. My senior is coming.
No, my lord. My lord, this is not for the first time. On 22/2 also remained absent, my lord. On 22,
you remain absent. You took a stay and thereafter you,
my lord,
you came and say that 138 matter I'll settle. I send it to mediation. You don't go there. Obtain a stay here.
My lord, notice was issued from the mediation center. Notice was returned unserved.
See, the matter, this present matter is arising out of a proceeding under section 138 NI. Since the petitioner has represented before this court that the matter can be recorded by out of court settlement, this court referred the matter to the mediation center. The mediation report dated 5/3/2025 indicates that the petitioner, due to non-cooperation of the petitioner, the mediation remain unsuccessful. Let counsel for the petitioner seeks an adjournment. Leaves the matter on 2nd of April. It's made clear that under no circumstances this matter will be adjourned. Yes.
Also one occasion 22/2 also failed, my lord.
Yes.
This is the subsequent debt failure. My lord, this is the subsequent debt
Interim
failure.
order is there, my lord. Interim order to continue.
No interim order.
That
Because,
interim order is the creating problem.
my lord,
If I will not pass the interim order, you will settle the dispute. I know that.
Today is for 24th.
my lord, the recall petition has already.
Within 7 days, nothing
1
will
minute,
happen.
interim order already there. Let's continue. Yes. Yes.
Hi, I'm appearing for OP 2 and 3. I have to file a objection to the petition, my lord. Let it come 1 week.
Who is for petitioner? Yes, sir.
103, Mr. Pratap Chandra Mishra.
None appears for the petitioner. Simply in the interest of the future, no, don't say any interim order, nothing. Mr. Sahu appears for the party and
2 and 3.
3 and submit
2 and
it's
3.
already filed.
No, I have to file objection.
He takes 1 week time to file the objection to the petition. Please the matter. Yes.
104.
Right. The notice has
My
been.
lord, in 104, your lordship, I have been instructed by OP5 to appear in this case.
Mr. Mahapatra, Land Council for the petition.
Not file the work.
Land Council submits that OP5 has instructed him to appear and he would be filing Vokalatnama in this matter. Leaves the matter on form. Yes.
105.
This is started by matter relating to matrimonial dispute. Matter relating to matrimonial dispute.
105?
No, 104 or matter relating to matrimonial dispute.
Matrimonial. Okay.
My pleasure, lordship. This is an application of on sale house. Last occasion, your lordship has directed to IAC whether the sale house required for investigation or not.
Sorry?
Last occasion, your lordship has directed IAC Tirthol whether the sale house is required for investigation or not.
Not required. The instruction has.
Not required. Then I'll allow it. Regarding the matter, but not forthcoming instruction. Yes. Yes. Wherever. Which order you have challenged?
No, there is no order. The house is sale. Seizure has been made. The
I understand. Where is the impugn order? Show me the impugn order.
No.
Have you approached the court, trial court? No.
No.
Straight away you came here.
Yes.
What is the stage of investigation?
Investigation going on.
You are one of the accused.
Yes. I am the co-accused. I am the owner of the property.
Huh?
Owner of the property and I am the
One of the accused.
Yes.
Okay. Which house is seized now?
Under Khatyana 378. My prayer. Page 9, my lord. Khatyana number 378 under Mauja Dagarpura, Tahsil Kujam, D. Jagatsinghpur. GR case number 401 of 24 pending in JMFC Tirthol arising out Tirthol PS case number 3.
Petitioner is aggrieved. In this petition is seeking
on sale of residence
directions.
Yes, madam.
For de-sealing of the residential house under Khata number so present so. Petitioner is one of the accused in FIR number that is Jagatsinghpur Tirthol PS case number 337 of 2024 for alleged commission of offences punishable under section so bar. Case 12. The allegation against the petitioner is that he along with the co-accused Subrat Kumar Mishra.
Yes, my lord. Subrat Kumar Mishra is the principal accused.
Manufacturing, storing, and selling counterfeit products of Castrol, TVS, Gulf, Bajaj, Honda, and Hero inside the residence, workshop, go down. and also store duplicate material of the above mentioned companies on the courtyard in the backside of the residence. During investigation, the subject premises has been sealed. This court issued notice to the opposite parties on 27/1/2025. Pursuant to the said notice, the IIC Tirthol PS has submitted a report dated 26/2/2025, which reads as a the perusal of the report reveals that the premises subject is no more required for the purpose of investigation. Therefore, the IO has stated in the report that the investigation of the case is substantially in progress and the sealed house is no more required for further investigation. In view of the report dated 26/2/2025, furnished by IIC Tirthol PS in regard to the FIR number so and so, the frequency RLMC is allowed. The IIC Tirthol, the IO of the present case is directed to take necessary steps for desealing the house within a period of a week if no further developments is required. Yes.
Hello.
Hello.
6.
Tomorrow, genuine charger. You are send to whom? Dharamsala. Huh? Dharamsala in Orissa or somewhere in Chandigarh. There is a police station in Dharamsala. Is there any police? Hey, we have sent it to Dharamsala only. What is your problem? Here nothing is to Dharmagada. No, here send it to Dharamsala. Don't worry. Dharamsala. Right. By order dated 12/3/2025, the IIT Dharamsala was directed to submit a technical report. The report was not been received by the state council and successful. We sit up to this. Yes.
Please, Your Lordship. Your Lordship, in our last occasion, we are stuck at one particular point regarding the connection between the petitioner and the stranger property amount. Your Lordship, I have 3 points to place before Your Lordship. Your Lordship,
I pose some question. Where is that sleep? Where is it? There was a written note of submission. Yes, I got it. Yes.
one computation.
Yes.
Your Lordship, we were stuck at one point where the question was what is the relation between the petitioner and the stranger?
I didn't get stuck. You get stuck.
Yes, Your Lordship.
When I asked the question, you couldn't answer. You
Yes,
thought
yes,
it
Your
out.
Lordship.
Yes.
Yes.
Now you answer it.
3 points, Your Lordship. The first thing, Your Lordship, the prosecution is not disputing this particular amount in their account, in their objection, Your Lordship. The second thing, as far as the information from the client, it says that the one brochure relating to that particular property has been found during the time of investigation. As to that, the amount, property has been added to the amount of the property has been added to the deed.
It stands in somebody else's name.
Somebody else's property.
The brochure is recovered.
Your Lordship, there is a DSR report in
Show me that. Show me that.
in the computation sheet itself.
Where is that?
In the computation sheet itself, Your Lordship, the DSR report shows
That
that
is-
the property
That
doesn't.
is 5,58,500.
Yes, Your Lordship. That the property doesn't belong to the petitioner, it completely belongs to that one person named Shailesh.
Where come I get that the brochure was recovered from your house and that the property?
Lordship, how the deed has been done, the prosecution has to say, Your Lordship. I have only this information that the brochure has been found.
Information through what process?
Information from my client itself, Your Lordship, that brochure has been. Meanwhile, Your Lordship, the property has been sold by Shailesh Pradhan, Your Lordship.
Sold by?
Sold by Shailesh Pradhan. Meanwhile, during the check period, Your Lordship.
It was in the name of Shailesh.
It was in the name of the Shailesh Pradhan, Your Lordship. I can show you initial.
If that 5,58,500 is taken out,
Yes, Your Lordship.
then it reduces to what?
It reduces to 3% day, Your Lordship.
No, it
Your
reduces to
Lordship.
19 lakhs.
Your Lordship, the prosecution is not questioning this 5 lakhs amount. The prosecution is only relying on one point that there is no intimation letter to the known source of income. As to that, the intimation letter is concerned, Your Lordship. Kindly come to page 83. And it's shared 4 series, Your Lordship. The intimation letter has been given.
Yeah.
83 and 84, Your Lordship. And there is no transaction of amount from the petitioner regarding in relation to that particular property, Your Lordship.
Hey, what is this 83 for?
83 is intimation letter.
Intimation to?
Intimation, intimation of carrying business of particular, the known source of income, Your Lordship, which is in the computation sheet is the 12 lakhs of amount, Your Lordship.
No, you are missing the point.
Yes, Your Lordship.
You are bringing some other point. You first satisfy me that 5,58,500, the property
Yes, Your Lordship.
belongs to one Shailendra. What is that name?
Shailesh Pradhan.
Shailesh Pradhan.
Yes, Your Lordship.
Shailesh Pradhan has nothing to do with you.
Nothing.
That property belongs to Shailesh Pradhan,
Yes.
and that cannot be factored into your known source of income. You just satisfy me there.
Your Lordship, the prosecution has to say how they have linked this property. The only on the basis of the brochure that has been found during the time of investigation, they have just done it.
That's what is the only thing. And what about the other amounts?
The other, as far as the other amount, Your Lordship, if you calculate it, it comes down to below 3%, Your Lordship. If we calculate, Your Lordship, the amount which is mentioned there in the computation sheet, 12 lakhs, 2 lakhs.
Yes,
and
Mr. Maharana, you just answer me 2 things. One is 5,58,500. The case is, it belongs to some Shailesh Pradhan, this property. When in the raiding time, you got the brochure of that property lying in the house of this vehicle, and you took that brochure and the amount you put it in the account. This is one problem. How you can find anything anywhere. You go to somebody's house, you will find many brochures. Whether he has purchased anything linked with that man, nothing is there. Second is 8 lakhs loan. See the written notes he has given. 8 lakh loan he has got from the bank. That loan amount is also included in the asset list. If 8 lakhs and that 5,58,000 is taken out of the record, it straight away come down to 3 or 4%. What kind of
That is true. Page 4.
You first satisfy me there.
Page
5,58,000.
That property admittedly that belongs to the one Sales Pradhan, that one statement of the DSR is also there.
Show me that. Why have you then included that? Because a brochure is found in it.
That has been given.
Even if the sale deed is found, somebody's deed might be in there, somebody. Suppose in your house some raid takes place.
Unless that is monitored.
And some property belongs to me, sale deed is lying in your house. You will include that property also.
Unless there is a
It is only brochure, not even sale deed. Okay.
That is there.
What, show me that.
That's one statement they have given in the notes.
Yes.
PSR statement.
Read it out.
1, 2, 3, 4, 5, 6 line. As per the document and sell deed selector so and so, plot number so and so, Kasa Bhubaneswar, Barmunda Bhubaneswar, unit so and so, has been registered in the name of Sales Pradhan on behalf of Sri Pradipta Nanda. So that is also in behalf of another person has been purchased. So that aspect I have not objected to that in my objection also. So far the only objection is there. For sake of objection, I have given that para 5.
Para 5
of my objection.
Of the objection.
Your counter.
By the IU.
Para 5.
Your Lordship,
Yes,
as far
para
as the
5.
intimation letter is.
Wait, yes.
Para 5.
Yes.
That is submitted that same may be the documents now they are relying, that is annexed 3 to 5, may be public documents and now part of the prosecution record. However, as per charge sheet, the aforesaid incomes have not been considered by the IU because the petitioner has neither taken permission from nor given intimation to its competent authority to that effect as required on for that purpose that income has not been.
That is a departmental. You can take departmental. That is I think that is the rule.
That is the
rule 54 or something.
Yes, sir.
It is required that if a government officer acquires some property, he has to intimate it to the 21 or I don't know what is that rule.
21.
He has to do it. If he doesn't do it, you can't fasten a criminal liability. Departmental, he will proceed, he will lose the job, whatever.
Now, business is there, that is admitted. I have given the objection.
The wife's business.
Wife's business and
wife is a co-accused.
Wife is a co-accused and another aspect is every document part of the prosecution record and public document.
Yes, Your Lordship.
Now, what happened to wife?
Wife, that is judgment is reserved. In the wife, only one foot is there except that there is no assets.
Why are you harassing people?
2004 style of investigation.
Because of your fantastic style, people are suffering. What is this? Why are you harassing these people like this? I'll pass the order. File a detailed written note.
Yes, Your
If
Lordship.
you want to file.
Yes, Your Lordship.
Yes.
Obliged, Your Lordship.
And tell me the status of that case, the wife's case.
Wife judgment reserved, open open court, my lord has held that it will be allowed.
I'll wait for that.
Order how?
Yes. You file a written note, let us see.
Yes, Your
We'll
Lordship.
see.
Yes.
Okay.
Grateful, Your Lordship.
Yes, judgment reserve. Argument heard, judgment reserve. And sir, I just pass the order. Learned counsel for the same learned counsel for the petition submit that the petition of the co-accused being CRLMC number.
It is
474 of
474 of 2005.
474
474,
474 of
2025.
2025.
No. CRLMC 3657 of 2024. 3657 of 2024.
I am not asking your petition. I am asking your wife's petition. Yes.
Wife.
Has already
Judgment is
heard by the coordinator. Judgment is resolved. Judgment is resolved. Let the petitioner, let the state council, let the counsel for the witness indicate regarding the outcome of the scene. In the meantime, petitioner as well as the vigilance council to file their written note of submission. Judgment is reserved.
Objection to break
In the form of a written note, also you give same thing. Yes.
One thing, if a lordship is going to allow, then it will not act as a precedent for other cases. That will
The facts of every case is different.
Every case is to be on its diluted in its own merit. It's a DA case, so it will otherwise that in view of
DA
that-
case, every case has different
wife-
accounting.
wife ର case for good case 7 file ହଉଛି କିନ୍ତୁ though there is no link. ସେଥିପାଇଁ କହୁଛି peculiarity consider the peculiar nature of the case.
Yes. Only peculiarity and
that
yes. Yes.
109.
Can you be taken by one week after?
No, 109, yes.
Number 2.
Can you be taken by 1 week after?
Okay. Request है जो ना.
110.
110 may please your lordship. Last occasion your lordship directed me to submit copy of the charge sheet and 161 statement. Thing is that there is in this case dispute between mother and son and daughter and grandson. Mother, as per annexer 3,
Seizure statement
informant of the
This is mother statement.
informant of the case he already died, my lord.
Died.
Mother,
Informant
my
died.
mother,
Informant is the mother.
mother, informant
That is her statement, man.
mother lost case against
Mother of the
petitioner. Petitioner, all the petitioner, mother, doctor,
If your lordship goes
and
through the
grandson,
statement
my
of
lord.
the informant, my lord. Informant who has died. Died. How will you prove it? That is 161. To know the backdrop of the case, my lord. Now, what is the solution? The informant is the mother. My lord. She has died, and they are the children. What are the allegation? Allegation is they drove out her for the property. The family member drove out her for the property, my lord. 10 or 12 days. Now she is died, my lord. They have the informant has they are very, very bad children, but what to do? She has died, my lord. With heavy heart, she might have died because of the conduct of the. My lord, that is the case. That is the case. But how will you prove the case? Because she herself is the informant. She has died, and the children have very badly behaved with the mother. That is the case. What to do? What are the other allegations?
No, my lord. Thing is that she has alleged that they all the petitioners abused her in Hindi language inside a room and a residential room in a public place. 294 will attract in a public place. 294 got. Let us come to 427. What type of property got damaged? Concept, asana, glass, all these are. That was not seized by the police.
They drove out and thrown the utensil, etc., my lord.
No, tapare she has described in the petition statement. Mate tapare combat kondele koile gharu ko avi.
But whatever you have tortured.
Yes, that is there, my lord. They are not criminals. This is the criminal case instituted instead of domestic violence can be made out. But they are not criminals, my lord.
And what stage?
Grandson to the condition karo. Your lordship is king of this empire. First jurisdiction, your lordship 482. Inherent power. But magistrate are less power. They can convict the persons, my lord. In the grandson will convict, my lord, his future will be in dark.
While torturing the grandmother, he should have thought it.
There is a dispute with regard to
grandmother at this age, he would not have filed a complaint against all the sons and daughter, granddaughters, grandson and all, unless something harsh has happened. Something harsh has happened. At what stage are you coming here?
Charge sheet has been Cognizance order challenge, my lord.
You should, according to me, you should face for something.
The conviction, your lordship has vast power, but magistrate has less power. That is why I have tried for it to be.
It's all right, but you have tortured your mother. You can't be, let go like this.
We will change our behavior.
Let's consider to pay some heavy costs. Your lordship has vast power. Paid to whom? Because evidences are there, not that evidence is not there. Statements are there. Sufficient material.
And
is there to
the
restrict
neighbor
it.
is also stated.
And sufficient material is there to allow also. That's another problem. I'll consider it, let it be. Yeah?
Might.
I'll consider. Simply urgent of 2 weeks, I'll consider. That is very bad. The allegations are very mean allegation.
One daughter and
Mother, the old mother
Yes.
against the sons and all. I'll consider.
kindly pardon.
Okay. Okay. Yes.
My lord, dispose of, my lord. Dispose of.
No, I'll consider it. Let them
dispose.
suffer. The
Dispose of.
pendency of the proceeding itself is
My lord, dispose
pressure
of.
on them.
My
Let it be. So for some time, I'll cause it. It has to be caused. That is not matter. That has to be caused. Yes. All now appeals.
Yes, my lord, is a part-heard matter. My lord may recollect that matter. I had argued it on a couple of occasions. Initially, the director had approved a set of accused persons. Petitioners were not there. Thereafter, the IO, after 3 years, picks up his own set of accused persons and vigilance. They have been taking time repeatedly in this.
Who is your friend? 111.
Mr. Rizvi is 2018.
I believe they are one.
Mr. Das,
Mr. Das is conducting. Sorry, he's there.
This repeatedly, my lord, my friend has been taking time.
While I saw him, Mr. Das, while entering, he was looking at the watch.
This is one simple case.
He has made up his mind to his defense.
No, that's not the point. I was watching all these thing on the boards.
Yes.
There's no point in escaping in my lord. The only thing is that these are the matters, my lord. So many factual aspects, and in fact, learned senior after his arrival in this particular case, my lord, so many documents has been introduced by resorting to Right to Information Act. I don't say that's wrong, but what I said, my lord, it requires time to, my lord, to put forth effective rebuttals, my lord. That's the, my lord, I think breathing gap of 10 minutes, 15 minutes, and all this thing. Now it is 15. If your lordship insists, my lord, then I will place it.
I will.
But it takes time.
There are matters which are pending, see 2018 matter.
Agreed, my lord. Lordship, take it tomorrow. Let's say weekly list, my lord. Lordship,
Let it be retained in the.
No, it is there for the entire week.
Let all these matters because
it is there for all the.
This is very short, it's very short point.
All these matters, let it retain in the board. I will, if I take from tomorrow onwards, I think all admission press matters will be deleted. So I may exhaust my board by 2:33. Thereafter, I'll pick up one after another. I'll pick up your matter also. 118. I'll pick up all the matters. Let it be there on the board.
I have also a matter, 117, my lord.
Yes, I'll pick up one after another. Whoever is ready, I'll hear it. Okay. Thank you. Oh, pass over. Yes.
Item 100. Item 100, I am for the petitioner, my lord.
100.
They took Passover, no, my lord.
What is this matter?
My lord, it is, I am for the petitioners who are the parents-in-law of the informant, and it is completely a matrimonial dispute. The wife is residing separately for the last 10 years, admittedly from reflected. Yes, in the affair. Yes, so matter may kindly be referred to the mediation center, my lord, to just to arrive at a conclusion.
For a mediation, weeks or
No, husband will also come. He is residing in UAE, my lords. He is in Dubai right now. He will come.
We see. Regard being head to the nature of allegation made by the opposite party against the petitioner, and the fact that the counsels appearing for both the parties conjointly submit that the parties may explore a possibility of settlement. Matter is referred to High Court Mediation Center. High Court Mediation Center. The parties are at liberty to appear before the mediation center through video conferencing mode as well. Lease the matter on, sir.
My lord, interim stay, my lord.
Interim
stay may kindly be
in the
granted.
meantime, petitioner is entitled to move an application before the trial court seeking an adjournment, owing to the fact that matter has already been referred to.
Deeply obliged. Much grateful.
Yes.